May I pray for taking up
Pray for listing, give it to the court master.
unless today itself, your lordship.
Why?
There is an urgency, your lordship, a transfer order has been issued to take effect immediately, your lordship. That's why it's extremely urgent, your lordship. I have taken the consent of the other side also.
Okay. All of the prayer for listing, please give to the court master.
All right.
Next, Lordship. I beg to mention item number 10, Lordship. In this case, Lordship, we are going to file Wakalatnama, fresh Wakalatnama. We are engaged recently, yesterday only, Lordship. So 1 week time maybe given, Lordship. And I have also informed
10 matter, 2012 matter, we are not adjourning it.
only yesterday, Lordship, we are.
That is your problem.
And
2012 matter at no cost. I am adjourning it.
only for 1 week, Lordship.
Not even for a minute. 2012 matters we are not adjourning. We'll have to take up the file.
Lordship, with the consent of other side, I beg to mention item number 15, Lordship. In this case, what happened, Lordship? Earlier,
2016 matter.
yes,
no.
Lordship. Earlier, Mr. Eugener was there, Lordship. Now the parties wanted to change the council, Lordship. So only 2-3 days accommodation, Lordship.
16 matters,
Yes.
16, 17 matters I am not adjourning.
May I please, Lordship? Lordship, with the
We'll call the matter, then we'll see.
Lordship, with the consent of the other side, Lordship, may I beg to mention item number 4 of today's video, Lordship. In this case, original record was called for, but I have not received, Lordship. On any date, Lordship.
When do you want?
After 1 week, Lordship.
You give it.
Or 29, Lordship. 29 is
Okay.
wait,
List, both sides are represented. List on 29, you're taking consent?
Lordship, I have taken Lordship.
List on 29, 5/2024, so as to enable the learned CEC to produce the records.
May it please, your Lordship. My Lord, with the consent of the other party, I beg to mention item of number 5, my Lord. My Lord, the conducting council is out of station, my Lord. Kindly adjourn the matter.
Both sides are represented. On the prayer made by learned counsel for the petitioner, list after
2 weeks, my Lord.
2 weeks.
I am for respondents.
Also, it's a present.
Wait, please, your lordship. I beg to mention item number 16, lordship. 16, 1/6, lordship. My senior is out of station, lordship. Took accommodation for today.
Yes, 2019, okay.
Because I'm appearing for the other side. There's a difficulty is that there is a stay order against the recovery of penalty the last 5 years. My IA for vacating is also since 2020. Any short date may be given because he's retiring in the month of July.
Okay. We'll take it up on Friday then.
Friday.
List on. Now, what is the representative? List on 17/5/2024. List of- If for any reason the writ petition cannot be taken up, the interlocutory application shall be taken up.
Stabilized.
May please, your lordship. Lordship, I beg to mention item number 18, 19, and 20, lordship. With the consent of the other side, lordship, matter will be adjourned for today. lordship.
Correspondent is.
You are for respondent.
We are for petitioner, lordship.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned today. List after 2 weeks.
My Lord, after 3 weeks.
3 weeks. Okay.
Obliged.
May it please your lordship. Lordship, with regard to item number 3, with regard to item number 3 of the daily list, lordship, we are going to file an affidavit in reply. I've taken the consent of other side, your lordship. I'm for the petitioner.
Item 3,
Yes, your lordship.
you have informed the other side.
Yes, your lordship, I have informed.
All sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned to enable him to file affidavit in reply in the matter. List after 3 weeks.
Lordship, on 30th of May. On 30th of May,
30.
30. Lordship,
No, 30 is Thursday. 31.
31. Oblige, your lordship.
Lordship, I beg to mention item 12 of today's daily list, Lordship. It's,
12 is 2012 matter.
I need to file my Wakalatnama in this matter, Lordship. Otherwise, Lordship, it relates to
No, even if the Vakatna is there or not, 2012 matter, I'm not adjourning. without taking it up.
Item 1.
Maybe Lordship.
You've got the instructions.
Lots of instruction is there. So already he has been placed for review medical board and his case is rejected. Yeah. The first question.
File an affidavit then. In the review also you were out.
My lord, but my prayer is for appeal medical, my lord. My prayer is for appeal medical board, my lord. Review medical has already been rejected that prayer, my lord. That's why I am before a lordship. And the similar matter, the honorable court has directed to the respondent authority and appeal medical board has been conducted, my lord. But let
No,
them file. my
it
lord,
can't
affidavit.
be. It can't be. You have to amend your petition. This review medical board.
My lord. Page number 21, my lord.
No, review medical board you have not challenged. This review medical board was on 26th April.
January, my lord, 2024.
Huh?
A review medical, that is page number 21 of my petition, my lord.
21.
Yes, my lord. That is the review medical examination, my lord.
But Mr. V. Kumar, let me consider the petitioner.
On behalf of Rita Devi.
And Mr. A.R. Tribal Dal and CEC appearing on behalf of Ms. R. Devi.
Miss Sada, yes.
Learned
On behalf of
CEC.
Devi, CGC.
Next one. The petitioner claims that an appeal medical board be constituted for by filing this writ petition under Article 26 of the Constitution of India, the petitioner is seeking a direction from the respondent authorities to have the petition examined by a appeal medical board.
Review medical.
Huh?
Review medical. Review medical board,
Review has already been done. There
My-
can't be two.
my lord.
Review cannot be, there cannot be two review.
No, no, my lord. I am praying for appeal, my lord.
I said appeal, then you say no. Please
My-
hear us.
Sorry, my lord.
On rejection of the candidature of the petitioner in the medical examination as well as review medical board. This was the examination by review medical board. Explanation notice written over in 4 weeks. Requisite extra copies of the requisition will be served on the learned CGC in the course of the day. Next part of the pendency of the petition shall not be a bar for the respondent authorities to examine the prayer made by the petitioner for the field medical board. Next one. Pursuant to the order dated 22/4/2024 and 29/4/2024 from instructions from the respondents was produced. First of power. The part of the instructions is already a part of the pleadings in the writ petition. So they could, accordingly, the instructions are returned. Next, for at least after 4 weeks. This is already there.
My lord. DPL, your lordship.
Item 2,
My lord, Steve, it will taken after some time, my lord. Ask about the timing.
item 6 with 7,
My lord, kindly matter may be taken up after some time, my lord, since petitioner counsel is also not there.
After some time.
I'm deeply obliged.
item 8,
May it please your lordship, on the last occasion, we were asked to serve notice on the private respondent. We are seeking 1 week's time to complete the service.
Please will call for the petitioner. Mr.
I brought
I brought up the limit. Can you go for the forest department? Please for. So for the time to serve notice on the private respondent number is 6 to 10.
Now it's time for.
Here is allowed. Matters can adjourn today. List after 2 weeks.
problems.
item 9 for hearing,
May it please the lordship. Here, the petitioner
Just
is
a minute.
claiming for notional benefit, my lord.
Just a minute.
Lordship.
He is already superannuated.
Lordship.
He is already superannuated.
He was superannuated, your lordship. During the pendency of the writ petition, and reading the date.
Yes, Mr. Sudhir. Here your stand. was that-
30/11/2010.
Here your stand was that the DPC may take up the case of the petitioner later on. So what has happened thereafter?
He retired on 30/11/2010. your lordship.
my lord.
Lordship, certain date would be relevant, my lord. May I please sit?
The public proceeding was drawn and the public proceeding was
Was
drawn
closed, my lord.
and disposed of with a penalty. That's why that was, it is a kept on seal cover during that
I
purpose
understand.
period.
But after this, you'll have to open it someday.
Open it, there's a penalty is there. If it is there is no any penalty, then it can be open and that can be given effect to. Because it is a seal cover and seal cover is open, here is a penalty.
No,
That's
no,
why
please come to this. Annexure one, page 46 of your affidavit.
Our affidavit, my lord. And it's A,
Your OM.
my lord.
Read number one. Yes.
Yes, 3rd November 2009.
No, 17 October 87, your affidavit.
My
Yes,
affidavit.
Annexure B.
And it's a B.
So annexure one, in my copy it is annexure one. Office
So-
memorandum of 1710,
Yes, your lordship.
Or 17, this is the office memorandum.
C number one.
Number 1, the undersigned is directed
No,
to.
number one.
No, no. Number one, a department proceeding have been.
What is it?
OM খনৰ দেখোন, সেইখন cover হয় আমাৰ।
এখন পঢ়িবই নোৱাৰি ভালকে।
মই সেইটো দিছো, সব type কৰি reply কৰি, তোমাৰ reply. We have also annexed in our reply, no? That same OM. Type copy you have given. Annexure one.
That is your affidavit in reply, right?
Yes, ma'am.
Right,
The office memorandum, I have got it, my lord. 17 October 87.
Yes.
Yes.
The procedure to be followed with regard to the promotion to be considered in case of award of
Number one.
penalty.
Serial number one.
Still number 1, when a departmental proceedings have been ended with the imposition of minor penalty, censure recovery of pecuniary loss to the government, withholding of the increments of pay and withholding of the promotion, the recommendation of selection committee in favor of the employee kept in seal cover will not be given effect to.
But in case of employee consent for promotion, confirmation may be considered by the next selection committee when it meets after.
When
conclusion of
it
department-
meets after the conclusion of the departmental proceedings. If the findings of the selection committee are in favor of the employees, he may be promoted in his turn. If the penalty is that of censure or recovery of pecuniary loss caused to the government by negligence or breach of orders, in case of employees who have been awarded the minor penalty of withholding of increments or withholding of the promotion, promotion can be made only after the expiry of the penalty. That is true. So during the promotion of the performer respondents, my lord, it was kept in seal cover. So, so far this office memorandum is this concerns, my lord. So he is not given effect to because he received the award of penalty.
I understand, but once that penalty is
Yeah,
is
expired.
over,
Expired.
then he has to be considered for promotion.
That can be considered, my lord. After expiry of the penalty, he will be, in the meantime, performer aspirant has already been promoted. That is the case, my lord.
Lordship, from 27/7/2009 to 3/11/2009, department proceeding was there, which was resulted in punishment of censure, my lord. Then thereafter, on 16/12/2009, performer respondent was awarded promotion.
2 weeks.
Lordship, I have given one sheet, your lordship, on the earlier occasion, the chart I have given.
Then it's not here.
मुझको delay लगी तो ना लेकिन more minus.
Yes, please. Even 3,000 with respect to the data to the BPC and recent legal definition of the information that was the difference between was all the rules and method from what's the problem of
On two occasions, my lord, 16/12/2009, 9/9/2010.
This censure related to the
misconduct.
which year?
Censure, my lord, I have, in my writ petition, I have annexed, my lord. A DP was drawn up. Lordship, can we have a look,
Related to which service year?
my lord?
When he was in deputy commissioner looking for
Lordship, annexure at page 24 of the writ petition. He issued certain permanent residence certificate. For that reason, DP was drawn up, my lord. Notice was issued on 27/7/09 and 3/11 it was dropped.
It was not dropped.
Lordship, it
It
was
says that-
resulted in awarding of censure.
Censure, so
My lord.
that will relate to which year? So which year, service year? Because it is only thereafter he'll be considered.
My lord, it was awarded, it was, censure was awarded on 3/11/2009.
3/11/2009.
11/2009.
980.
Hmm?
first, he was, when he was posted as Lakhimpur ESC by Governor to 1980, accordingly, his past pay slip was, it is not on that, should the petitioner
No,
serve
the
with
figure,
the.
you see, I'm trying to understand that supposing on 1/1/2020, somebody did a misconduct and proceedings were drawn up, and on 1/1/2024, order of censure was passed.
Pass.
That will relate back to which year in the ACR? This will be entered in which year's ACR?
Lordship. So record
Do-
will, your lordship.
1/1/2020, he did a misconduct. Departmental proceedings started. He was awarded a censure on 1/1/2024.
24.
The question I'm asking is, this will be entered in his service record for which year?
Oh, he's SCR.
The
Yes,
SCR.
yes, I understand, my lord.
So it's up to the.
Because,
PC,
my lord, he
your lordship.
3 years, SCRs, my lord, in 2024.
Now, I don't know, because if it is 2024, then in the next ACR, he should be considered because he has already been given promotion with effect from, the petitioner given effect, promotion with effect from 1/7/2010.
Yes.
So he gets the benefit. Notional benefit of pay fixation and all will be given to him.
2010, in the meantime, by my lord, 2010, he's censured, my lord. Retired person. He retired
You
from
see,
service.
He was, the censure was 3/11/2009.
9.
He was then promoted with effect from 1/7/2010 by an order dated 28/3/2011. That
Yes,
is
my
post
lord.
facto.
So in 2009, my lord, censure is there. This year will be affected, 2009. Because censure was, in the Department of Proceeding was disposed of awarding censure, 2009.
Should not be. Because you say that you claim that it is in a seal cover procedure.
Seal cover
So
procedure.
seal cover procedure will always relate back to the year in which for which the ACR was under consideration.
Seal cover procedure, my lord, if it is, there is no any penalty, then it is from that. When it was kept on seal cover, from that will be affected. If it is, my lord, kept in seal cover procedure, and it is, my lord, penalty is awarded, the opening of meaningless, my lord. He will not get it.
It's okay.
The junior will definitely will go on.
That's okay. But you are trying to say that even if the misconduct was of the year 2009,
2009.
the entry will be made in his ACR in the year 2000, 2009 after the okay.
2009, my lord.
Okay, 2009. Okay, right. But then if he has been given promotion, he will get the consequential benefit.
My lord, I think, well, he is not entitled because the former
No,
respondent,
once you give promotion, you can't say that you will not be entitled to the notional fixation of pay.
he says that when the junior was promoted with effect from that 2009 to 2010, and September 2009 to till his retirement. Hello, one instruction I have received in 2023, lordship, kindly, I am going through it. But for a moment, my lord. The power getting reduced to
Lordship, we are, I am claiming benefit with effect from 16/12/2009 on the date when the private respondent was given promotion. On the date, there is no DPC, my lord. Since the DPC has considered his case, my case should have also been considered, my lord.
And DPC for consideration of promotion of officer in the rank of additional secretary was held on 29/6/2010. And the DPC, Sri Deepak Kumar Goswami, was recommended and accordingly promoted to the grade of additional secretary on 1st July 2010. By the order dated 11. Matter of promotion of Sri Kamalasa Goswami was also taken up in the DPC held on 17/8/2009. His name is Kamalasa Negi. A promotion of Kamalasa Goswami was also taken in the DPC held on 17/8/2009. And a decision regarding his promotion to the date to the additional secretary was kept in seal cover due to pendency of departmental proceeding, which was initiated on 29/7/2009. Departmental proceeding initiated against the Kamaleswar Goswami were dropped on 28/10/2009, and he was exonerated of the charges which were framed against him, copy of which was enclosed, because the performer respondent was exonerated. And another orders is the promotion order.
Lordship, may I pray for the angel of justice, let them produce the records of the case
Okay.
of the
But
proceeding.
they've stated that, they've stated that in their affidavit, they say that the promotion order of the respondent was made on (28/1/2009). So at that point of time, there was a DP against you. You could not have been considered. So
Yes.
therefore you lose it. And therefore your junior gets a jump over you. So we can't restore back the,
Yes.
your position.
Lordship,
28/10/2009.
Para 5 of the affidavit in opposition, and in response to it, your affidavit in reply, para 5. Because on that day you had DP against you.
That question also earlier occasion asked
On
to the petitioner on the last occasion,
last day.
last date, he was there. So definitely, Malot, on 28/10/2009, he was promoted.
Lordship, today my learned friend is submitting, your Lordship, the DP was also against Kamal Losam Goswami, your Lordship. But that fact has not been brought on record by them, my lord.
You see paragraph 5, you have responded to it.
I am claiming benefit, I'm giving a prayer, your Lordship, to consider my case on 16/12/2009. 16/12/2009, this private respondent was, performer respondent was given promotion. And when the DP was held, I'm not aware of it, your Lordship, but
Where is the order of promotion?
Lordship, may kindly have a look at my repetition, my lord.
Page.
Lordship.
3rd November.
16/12, Annexure 4, page 20, my lord.
Page 20.
Kamalosan Goswami, ACS, Director Welfare to Scheduled Tribe, is promoted and allowed to officiate the Divisional Secretary to the Government of Assam in the scale of pay so and so, with effect from 28/2009 retrospectively, and transferred and posted as Additional Secretary to the Government of Assam Secretariat Department. This is by the order dated December 16/2009, my lord.
Just a moment.
Has your lordship got it, my lord?
Just a moment.
My lord.
Oh, it's very good. Really good. Private respondent was promoted 2008, 28 January 2009, and the
No.
petitioner,
That cannot be correct.
our affidavit paragraph 5 number.
No, but that cannot be correct. You see, Ms. Bria is relying on page 20, annexure 4.
Well,
Here, the notification of the governor is 16/12/2009. It's not January. Your paragraph 5 says January. That is incorrect. It's not supported by anything.
Petitioner was promoted on 1st July 2010.
No, please see page 20 of the writ petition.
20, please.
with petition.
This is notification of the governor in the name of the governor.
No, petition couldn't complete now.
With petition.
Seventeen October, is it? কোনখন কোনটো?
16/2009.
Page 20 of the writ petition. Yes.
Yes, madam. 16 December 2009.
So this is your paragraph 5 is incorrect.
Kamalasa so and so welfare Assam is promoted and allowed to officiate regional secretary to the so and so. With effect from 28/10/2009. Our affidavit, my lord, paragraph 5, 28 January.
That is incorrect.
Maybe, my lord. Typing mistake. A copy of the notification 23.
So if this order was passed in December, petitioner gets the benefit. You can't stop that.
I have 28 March 2011, Pradip Kumar Das, Deepak Kumar Goswami, Joint Secretary to Corporate Assam Tourism Department, has retired on 30/11/2009, is promoted and allowed to officiate in the cadre of Additional Secretary to Corporate Assam.
It is not a petition for the resource. Retrospective.
Or even if you take a hyper-technical view, stating that the departmental proceeding against the petitioner was pending till 3/11/2009. So at least on 4/11/2009, he gets the benefit
Petitioner.
because the junior was already promoted with giving a what you call
Retrospective.
retroactive effect. He was promoted by order dated 16/12.
2009.
Given retrospective effect from 28/10/2009. For 28/10/2009, there was a DP against the petitioner. So at least from
16/12.
it terminated on by censure by order dated 3/11/2009. So at least on 4, she gets the benefit.
Because Kamalasa was promoted on 28 October 2009. He's junior.
No, but the order is 16/12.
16/12, yes, my lord. Kamalasa Goswami,
16/12/2009. So either from 16/12/2009 or from 4/11/2009, whatever date. She gets the benefit.
16/12/2009, he is giving him retrospective effect from 28 October 2009.
That's not the point. The point is that the notification came on 16/12/2009 when there was no DP against the petitioner.
That is my case, ma'am.
16 December 2009.
On that day, there was no DP against the petitioner. So
DP,
her case could not have been ignored.
I will have to see, my lord. Better, my lord, I would collect the records, my lord, I would go through the records, my lord, because he says some typing mistake is there.
No, that can be 2010 matter.
Yeah, I understand, my lord.
We.
When there was no DPC against the petitioner, at that moment the junior promoted, he case could have been considered.
So they will.
That
make
is the point.
They'll make the calculation and they will pass orders.
Yes, I will
Will
see
be
the
for
records, my
benefit.
lord, let it be on, my lord, it is on, my lord.
2010 records you will not get.
Oh,
2010 records you will not get. So it's better that we dispose it of. Your authorities will get 1 month's time to take a decision.
yes, that can be. That can be.
Because 2010 matter to 2020.
May not be, my lord. But I have received some communication also 2023 only. That is the letter, 17 June 2020, they have stated something personal department, my lord. And matter of promotion of the Kabaleswar Goswami was also taken up with the DPC held on 17/8/2009. And decision regarding his promotion to the additional secretary was kept in seal cover due to his pendency departmental proceeding, which was initiated on 29/7/2009. Departmental proceeding initiated against Kabaleswar Goswami were dropped on 28/10/2009. That was the 28/10/2009 drop. That's why Kabaleswar private respondent was given effective from 28/10/2009 retrospectively.
Correct.
And if it is a petitioner is dropped,
No,
when
see,
he is
there-
dropped,
See, there are two ways to look at it. Number one, it is your instruction that the proceedings against respondent number 5
5,
was dropped on 28/10/2009.
9
Correct.
come to an end.
It came to an end. In the case of petitioner, it came to an end on
4/11,
3/11.
3/11.
So why
He-
there are two standards?
Yes. Yes, after come to an end of his effect of award, from that retrospectively, he should be given the benefit.
That's what
That
we are
is the
saying.
case.
So
Okay, Lordship can pass.
There
an
can be
order.
only two dates,
Yes,
either 4/11
4/11 or
or
16/12.
it will be 16/12,
My lord.
whatever they,
for few months, my lord, because in the meantime, 2010, he is retired.
for 20 days. 20 days.
Whatever benefit he will get, Lordship can pass the order because for direct them to consider it, my lord. Because I have seen it, private respondent, whenever he is disposed of the departmental proceeding, with effect from that, he was
So
promoted.
that is, so same standard will be applied.
Yes,
to
yes,
them.
I got the point, my lord.
But Ms. B. Bhuyan, Senior Counsel, assisted by Ms. B. Bora. It's B. Bora.
B Bora, Bombay.
No, B. Bora, General Counsel for the petitioner. Also heard
I am for respondent number, my lord,
Mr.
One.
A. Fukan Lanet, standing counsel for the respondent number 1.
I am for one,
I'm for.
I am for 1 and 2, 3
1, 2, and 3,
and 5, my lord.
and 5.
He
Okay,
is not made party.
okay, 1, 2, 3, and 5. Then Mr. R.K. Talukdar Lanet,
For fine.
standing counsel for respondent number 4. And Mr. Fukan, you will be for?
What happened was in this matter, we were called in, we were not made parties, we were called in to assist. Because we are the chief, but actually it's the personnel department, because the appointing authority is the personnel department.
Personally.
So that way matter my name.
Okay. This is there. Assisted by Mr. A. Fukan, and counsel for respondent number 1. The petitioner is a Assam Civil Service officer of 1980 batch. on 27/7/2009, a show cause notice was issued to the petitioner for issuing 32 numbers of permanent residence certificate by which a disciplinary proceeding was drawn up against the petitioner by first thereafter by an order dated 3/11/2009, comma, the disciplinary authority imposed a penalty of censure upon the petitioner by taking a lenient view against him. Full stop. Accordingly, the proceeding against the petitioner was closed with punishment of censure. Full stop. During the pendency of the disciplinary proceeding against the petitioner, the recommendation of the Departmental Promotion Committee, within bracket DPC for short, bracket closed, was kept, in respect of the petitioner, was kept in seal cover. Full stop. The performer respondent number 6, who is stated to be junior to the petitioner in the seniority list, was promoted to the post of additional secretary by notification dated 16/12/2009, issued by the Commissioner and Secretary to the Government of Assam, comma, personal within bracket A, bracket close department, with effect from 28/10/2009, with retrospective effect from 28/10/2009. Full stop. However, the petitioner was promoted to the post of additional secretary by notification. Where is it? Which page?
Lordship, it's with the affidavit in opposition. After filing of the writ petition, my lord.
Where is that?
Lordship. Annexure C, page 8. There'll be renumbering, my lord. Annexure C of the
By notification dated 28/3/2011.
third column.
With effect from 1/7/2010. Accordingly, the petitioner has filed a cert petition under Article 226 of the Constitution of India, seeking a direction upon the respondent authorities to give all notional benefits of promotion and other consequential benefit with effect from 16/12/2009, the date on which the performer respondent was given promotion. Next paragraph. The per contract of the learned additional senior government advocate had submitted that the DPC recommendation, which was kept in seal cover in respect of the petitioner, cannot be given effect to because the proceeding against the petitioner was closed on 3/11/2009 with the punishment of censure. And thereafter, the petitioner was duly promoted to the rank of additional secretary by notification dated 28/3/2011. Next paragraph. We consider the materials available in the writ petition. Affidavit in opposition filed by respondent number 4 as well as respondent number 1. And the affidavit in reply filed by the petitioner against the affidavit in opposition filed by respondent number 1. Next paragraph. The facts which is not in dispute is that the disciplinary proceeding against the petitioner was closed by order dated 3/11/2009 with the punishment of censure. So therefore, when the respondent authorities where is that promotion order of the respondent?
Lordship, annexure 4, page 20. Of the writ petition.
Yes, indeed. When the commissioner secretary to the government of Assam, a person within bracket E, that to department, had issued a notification dated 16/12/2009 to give promotion to the pro forma respondent number 6. On that date, no departmental proceedings was department or disciplinary proceeding was pending against the petitioner. Next paragraph. On a specific query made by the court as to why the pro forma respondent number 6 was given promotion with a retrospective effect from 28/10/2009. The learned additional senior government advocate, by referring to his departmental instructions received on, what is that letter?
Instruction proper dated.
Dated malade 17 June 2023.
Pardon me?
17.
June. That is discussed.
2023.
17 June,
17.
17/6,
Lot of things
2023
এখন দিলে।
has submitted that there was a department proceeding against the
That's one number 4.
performer respondent number 6,
Six.
which terminated on 28/10/2009, and therefore therefore, though the notification of his promotion was issued on 16/12/2009, the promotion was given effect from 28/10/2009. Next, if that be so, the same benefit is required to be extended to the petitioner. Because after the departmental proceeding was terminated with a punishment of censure on 3/11/2009, benefit similar to one extended to the performer respondent number 6 ought to have been given to the petitioner by treating him equally.
Petitioner is paying, but his pay is for December 2016.
That's okay.
16 December 2009.
No, that's okay. That's one part. So the authorities will have to take a call. Because you see, whatever we are doing is after taking note of Article 14. The authorities can't say that to X I am giving A and to Y I am giving B.
No, more depends. Only days.
Whatever be, one day also,
Yes, yes, yes.
it will
Principle
have a
is,
satisfaction.
principle is principle, my lord.
Okay. In that view of the matter, the court is inclined to allow this repetition by directing the commissioners, the head of the department's commissioner secretary, Mr. Fukan,
Chip,
who will consider the promotion?
Chip, the
Personal.
personal department secretary.
No, it is commissioner secretary or only commissioner?
Commissioner.
Personal department, मतलब principal secretary, I think.
Principal secretary,
Yes, but
Nowadays,
secretary.
principal secretary.
not principal secretary, the head of the department
Principal
of-
secretary, madam. Yes.
of personnel within bracket A
A
department
department.
from a government of Assam, which is presently held by the principal secretary, the government of Assam, personnel
like
within
A
bracket A
department.
department is directed to revisit the to re-examine the date on which the retrospective effect of promotion be given to the petitioner, namely Deepak Kumar Goswami. First off, as indicated herein before, the disciplinary proceeding against the petitioner had come to an end on 3/11/2009. However, the notification of his promotion was issued on 16/12/2009. Stop. Not 16. The 16 promotion to performer respondent number 6 was given on 16/12/2009. Stop. In this case, the petitioner was promoted by notification dated 28/3/2011 with effect from 1/7/2010. Stop. The said authority will have to reconsider the date on which the promotion of the petitioner be given effect to, which can either be 4/11/2009, sorry, the 4/11/2009, that is one day after the departmental proceeding against the petitioner was closed, with punishment or censure, and oblige on 16/12/2009, on the date when the performer respondent number 6 was given promotion. Stop. The head of the department, comma, person within bracket A, bracket O department, from which is presently being held by the principal secretary to the government of Assam, or person A department shall take a decision in the matter within a outer period of 6 weeks,
Oh, shit.
6 weeks.
outer period of 6 weeks from the date of receipt of a certified copy of the
Certified
order. Stop. Next paragraph is, needless to mention that as the petitioner is already superannuated, comma, he would provide his email address to which the result of examination shall be communicated to him. We are returning your letter, your instructions we are returning.
Time being item 6 with 7.
My senior Mr. H.K. Das is on legs in fourth one, Lordship. Kindly maternally passed over to the family.
Why it has come today?
Well, that actually, this is meant for admission disposal, madam.
Oh, acha. Okay. Just tell,
After some time. madam.
just tell Mr. Chaudhary when to come.
Yes, yes.
Item 10.
Lordship, if your lordship permits, it may be taken on Thursday, lordship. Because
No, no,
I have
2000
received it
you see,
today only.
2010, 12 matters, we are not adjourning. There is no way we can allow your petition. Your petition cannot be allowed. It's to be dismissed. Where is that departmental circular? Mr. Chaudhary,
If your lordship will come to page 23 of the writ petition, by which they are not allowed,
11.8.
11.8, yes. Page 23 of the writ petition, lordship.
And where is this 18.6.12?
18.6.12 is at page 40.
What, Mr. Your name?
SK Sinha.
SK Singh.
Sinha.
Singha. SK Singha and counsel for the petitioner. Who at the outset had paid for an adjournment. Which was declined. Also had Mr. Arkady Chaudhary and DSGA appearing for the respondents. Next paragraph. In brief, the case of the petitioner is that while working as RPSF, working in the RPSF, fourth battalion. He was his service was placed at the disposal of the FA and Chief Accounts Officer, NF Railway. As an accounts clerk. Mr. Here. The petitioner had exercised his option for interdepartmental transfer pursuant to an option given by the respondent authorities by letter dated 17/6/2008. Which was duly forwarded by the Deputy Director within bracket ABE Railway Board to the Deputy CAO within bracket G, FA and CAO NF Railway. Full stop. In the written examination for selection of accounts clerk, the petitioner had cleared this at examination and his name appeared in serial number 6 of the result of successful candidates, which was notified on 31/12/2008. Full stop. However, the Deputy Director within bracket ABE by a communication dated 29/1/2009 to the commanding officer, 4th Battalion, RPSE.
SF lotion. RPSF.
RPSF, okay. It was informed that as per board's letter dated 11/8/2003, RPF/RPSF personnel cannot be allowed to appear in what is full form of GDC? GDC examination. And they are also not eligible to appear in other departmental selections in departments other than RPF/RPSF. Accordingly, the NOC given to the petitioner by letter dated 15/9/2008 was withdrawn. Accordingly, the follow-up letter by the FA and CAO WST NF Railway issued on 5/4/2012 no, sorry, not that.
18/6, that is at page 40.
Accordingly, the consequential communication made by the director, public ABE, from a railway board dated 18/6/2012 to the FA and CEO of NF Railway. By which decision of repatriation of the petitioner to the parent battalion was issued, has been assailed in this writ petition. Next, the stand of the respondents is that where is this 11/8/2003?
11/8/2003, Lordship will find at page 23
23.
of the writ petition. It's not that the Ministry of the Railway Board under the Ministry of Railway made communication dated 11/8/2003 had notified a scheme of GDC examination for filling up of for filling up a part of direct recruitment quota posts in group C category. And it was decided that the selection of RPF, public RPSF staff under the GDC examination cannot in any way facilitate redeployment of surplus staff. And accordingly, it was decided that the RPF, public RPSF personnel cannot be allowed to appear in GDCE. Full stop. Therefore, the NOC given to the petitioner Lordship, at paragraph 7 of my affidavit, it was issued inadvertently, Lordship, page 6. Paragraph 7 of my affidavit, Lordship. It starts at page 5. In page 6, we say the NOC was issued to the petitioner inadvertently. That is why it was subsequently withdrawn.
para 7.
Para 7 of the affidavit, Lordship.
Para 7, you don't say inadvertent.
At page 6, Lordship. Oh, I'm sorry, Lordship. Para 8, Lordship. I'm sorry, Lordship. Para 8, Lordship.
What is the date of NOC?
NOC was issued
15/9/2018. Page 18 of the. 15/9/2008, page 18 also.
18.
Yes.
Oh, that is the application.
No.
Forwarding of the application.
I think this is the one. 18, he's right. The forwarding of the application of the petitioner by communication dated 15/9/2008 by the Deputy Director, ABE, Railway Board. Is expressly contrary to the communication by the Railway Board, Ministry of Railway dated 11/8/2003, by which RPSF personnel was disallowed to appear in GDCE, and they were also not allowed to appear in departmental selections in departments other than RPSF. Therefore, moreover, it has been made clear in the said communication dated 11/8/2003 that the past cases was decided not to be opened, not to be reopened. Next paragraph, therefore, if any personnel of RPSF oblique RPF a given promotion prior to the communication dated 11/8/2003 will not confer upon the petitioner any right to be absorbed in the establishment of FA and CAO, NF Railway. Till the time the said communication bearing number capital E within bracket NG bracket closed 1/2002 PM numerical 2/9 dated 11/8/2003 issued by the Deputy Director Establishment ESTT full stop within bracket N bracket closed Railway Board is in force. Any decision taken by the respondent authorities which is contrary to the same cannot be sustained. Therefore, the court is of the considered opinion that no case is made out by the petitioner for interference with the impugn order under memo number 2009/. SEC within bracket ABE bracket closed oblique CC oblique 2 oblique 9 dated 18/6/2012 issued by the director stroke ABE comma railway board. So accordingly, this regulation fails and the same is dismissed. Next paragraph. No, before that, you write. The petitioner has placed reliance on the order dated 15/6/2011 passed by this court in WBC 1455 of 2009. Where the respondents were directed that in the event the respondents want to take any action in the matter towards his redeployment in RPSF, he will be given the opportunity of being heard. With the further direction that the respondents may also consider as to the feasibility of continuation of the petitioner in the accounts department. First off, it is also noted that the letter dated 11/8/2003 was considered by this court. And it was held that the said letter was not in the form of any general circular, but was issued to the general manager within bracket P, bracket was SC Railways, Secunderabad. Stop. Nonetheless, the said communication is by the railway board. And it cannot be said that the said communication will not have a binding effect. Stop. The training and the deployment of the petitioner in the establishment of the FA and CEO NFLA Maligaon was subsequent to the said letter dated 11/8/2003, which is not under challenge. The consequential action of the respondents cannot be said to be contrary to the said communication dated 11/8/2003. So in this regard, we note that while communication dated 2012, which is annexed to the writ petition as Annex 1, Annex 5. That the petitioner was, the order dated 15/6/2011, passed by this court in WPC 1455 of 2009. Petitioner was given an opportunity of hearing. In view of the policy instructions dated 11/8/2003, the repatriation of the petitioner to the parent battalion was ordered. This one. In this writ petition, the petitioner is not assailed. The said communication dated 22/3/2012, nor the petitioner has assailed. The policy decision by communication dated 11/8/2003. So therefore, this writ petition fails. Then that last paragraph. Accordingly, the writ petition stands dismissed.
Time being item 2 for admission.
Yes,
I'm sorry, Malad, I could not appear in first call. I'm sorry for not appearing in the first call.
that's okay.
Malad,
You have already exchanged the pleadings have already been exchanged.
Yes, my lord.
If you are going for a hearing, then you'll have to wait for your turn. Let this entire, let this other list be over. There are older hearing matters. We'll take that first and then after we'll hear this. We'll come at the later part of the day.
Fix a date, Malad. Fix on another date, Malad.
No, every day will be same. We have on board 2010, 2012, 2014 matters. So if I am taking up the hearing, even the admission stage, it has to be deferred till the other matters are over.
This must be fixed in around the month of June, Malad, first week of June.
Yes.
First week of June must be fixed in Malad.
First week of June.
On Malad, 4th or 6th month.
Okay. Both sides are represented. As the board has older pending matters for hearing, the hearing in this matter is deferred. Next, as agreed to by both sides, list on 4/6/2024.
6, madam. 6 means,
4/6,
no, madam, 4, I have some
6.
difficulty on 6th of June.
6th, okay, 6th.
Must
6.
apply.
Item 11 for hearing.
My lord, one honest prayer before your lordship, my lord. One prayer before your lordship, my lord, let the matter day after tomorrow, my lord.
No, no. All matters we are not adjourning.
And my lord, my senior Mr. Gaur is on lag, my lord, court number
Wait after some time, let him come.
after some time. I'll call. Not, I'm like.
After some time.
Item 12 for hearing.
Lordship, I am not there in this matter, but I had talked to the petitioner, Lordship. He had said that, Lordship, most of the grievances have been met out, except one, Lordship. Lordship, his junior was promoted during the time when the departmental proceeding was going on, Lordship. And I have been told that, Lordship, he was exonerated of all the charges. So, Lordship, his case was kept in seal cover, and his due promotion, Lordship, the benefits, if he is entitled, needs to be given to him, Lordship. Paragraph 7 of the writ petition, Lordship, there is a statement with regard to the promotion, Lordship.
You see, mainly there was a delay.
Lordship.
It can't be a ground to set aside the. But the only prayer here is that on superannuation, I think this you are entitled to. Yes, Mr. Das.
Lordship.
You see, once he is retired, his other retirement benefits can't be withheld, that has to be released.
Lordship. Lordship, I have queried with the department regarding this case of the petitioner. They have stated that they have already paid and that nothing remains as far as my instructions, but no written instructions, Lordship. He has already been superannuated and
There's an
That's okay, but
There was an affidavit filed, Lordship. In that affidavit, paragraph 9, Lordship.
you're only
It was
referring to
stated-
subsistence allowance.
Lordship.
Those have been paid, Lordship. I have been instructed, Lordship. But only with regard to the benefits of promotion, Lordship, if he is entitled. Paragraph 9, they have stated, Lordship, that his case was kept
No,
under
no.
seal cover, Lordship. And what was the outcome, Lordship? That is not known, Lordship.
What is the result of the departmental proceeding, Mr. Das?
Lordship, departmental proceeding, seal cover has already been opened, Lordship, and he has been given the benefit, means the consequential benefit which he is entitled, for which he is entitled, Lordship. And during this time only the petitioner has retired, Lordship, superannuated from his service, Lordship.
Promotion, they how much departmental proceeding for yes, see how much is in
You superannuated when, Mr. Sharma?
Lordship in 2009.
Do you have a date?
Yes, Lordship. Twenty-eight to 2009
28,
to 2009.
Mr. Das, that is correct. 28 to 2009, he is superannuated.
Lordship.
Then after that, how could you continue with the proceedings under which authority?
No, that cannot be continued, Lordship, since he has superannuated.
But you see in your affidavit in opposition filed on 20 February 2013,
Lordship.
you are still writing that you are making an endeavor to for early termination of that departmental proceeding.
No, in paragraph 11, it was written that disciplinary proceeding was continuing during that relevant period of time. Lordship.
No. You see somewhere you have written.
And subsistence allowance, we have already communicated to the AG and it has
You
been.
see, come to internal page 6, para 14, 15, 16. Okay, affidavit. So in your affidavit, you have saying nothing
Lordship.
that you have reserved your right, how you have reserved your right, those are not there.
Lordship.
So we'll have to say that on 28/2, it has terminated. So whatever consequential benefit he gets has to be calculated and paid to him.
Lordship. Only if it is stated regarding the granting of subsistence allowance, the other benefit.
No. His prayer is to quash the departmental proceeding.
Lordship.
Show cause notice and everything has to be quashed.
Lordship. Lordship, may I pray for a week's time, Lordship, so that I can bring in the up-to-date information, Lordship.
No. 2012 matters, we can't
Lordship.
keep it prolonged.
I understand.
Because otherwise, if you don't reserve it, it will terminate. In 2013, when you are filing an affidavit, the respondents knew about it, but they have kept silent. So this has to be terminated, whether whatever has happened.
Lordship, in paragraph 19, Lordship, in our affidavit, that is page 7, Lordship, it has been stated that the answering deponent Bader begs to state that the concerned department has reinstated the petitioner in service before his
No,
retirement.
reinstatement is only
In compliance
after
of-
suspension,
Lordship.
because the High Court directed that his suspension be revoked. So only his suspension was revoked
Lordship.
before retirement, otherwise he would have been in other difficulties.
Lordship.
So that you have done.
And conclude the proceeding as early as possible.
Till date, you are not disposed it. So everything happened, has to terminate on 28/2/2009.
Can it be on Friday, Lordship, so that I can?
No. You can just make some accommodation for the day, but no adjournment.
Lordship.
So on and from 28/2/2009, he'll be entitled to his full pay and all consequential benefits.
Provisional pension has also been granted, Lordship.
Heard. Mr. M.P. Sharma, the counsel for the petitioner, and Mr. Anand Das, standing also for the Water Resources Department, representing respondent numbers 1 and 2. And Accountant General, you're there, Miss A. Sharma, Dhanab, standing also for respondent number 3. Next paragraph. The case of the petitioner is that while serving the Water Resources Department
Superintending.
in the as superintending engineer, North Lakhimpur Water Resources Circle, he was suspended by an order dated 29/8/2008. Full stop. Although the petitioner had filed an appeal against the order of suspension, discipline proceeding was initiated against the petitioner by issuance of a show cause notice dated 11/12/2008. The petitioner submitted his written statement in defense. Stop. He had also approached this court by filing a writ petition against the continued suspension. And this court by order dated 22/2009, passed in WVC 641 of 2009, directed the respondent authorities to revoke the suspension of the petitioner. And the respondents were directed to conclude the departmental proceeding against the petitioner as an early date, which should which in any case should be within 4 months from the receipt of the said order. Full stop. Resultantly, the petitioner was reinstated in service by revoking his suspension. However, on 28/2/2009, the petitioner attained the age of superannuation and retired from service. The retirement benefits of the petitioner was withheld on the ground that the department proceeding was pending against him. And though the petitioner had suffered a brain stroke on 5/6/2010, and a representation was submitted by his wife on 19/6/2010 for release of leave encashment benefits for his treatment, the dues of the petitioner were not released. Accordingly, after submitting a representation, the present petition has been filed under Article 226 of the Constitution of India. And the petitioner has prayed for quashing of the show cause notice, as well as the entire show cause notice dated 11/12/2008, and the departmental proceeding initiated against him for a direction to regularize the period of suspension with effect from 28/8/2008 to 24/2009 as on duty and to release all constitutional benefits. So the petitioner also claims promotion from the date from retrospective effect from the date his juniors were promoted to the cadre of additional chief engineer, water resources department. Next paragraph. At the outset, the Janet Stanikos for the water resource department had paid for an adjournment so as to enable him to obtain updated instructions as to the present status of the departmental proceeding against the petitioner. However, taking note of the fact that this petition which was filed on 7/12/2012 is still pending for disposal, prayer for adjournment was refused. Next paragraph. On the perusal of the stand taken in the affidavit in opposition filed by the undersecretary within bracket E, bracket closed, to the government of Assam, Water Resources Department. Now it is noted that the with the said authority by an order dated 24/2/2009 vacated the order of suspension of the petitioner and he was reinstated as superintending engineer. Stop. However, on a perusal of the statements made in paragraph 14, 15, and 16 of the affidavit, said affidavit in opposition, it appears that at least till 20/2/2013, the date when the said affidavit in opposition was filed, the disciplinary proceeding against the petitioner was not yet finalized. Stop. In the next paragraph, in the said affidavit, the undersecretary to the government of Assam, Water Resources Department, has not disclosed as to which power was invoked by the respondent numbers 1 and 2 to continue with the disciplinary proceeding against the petitioner after he had superannuated on 28/20/2009. Just take a break and come back. Which is the provision which says that if the departmental proceeding continues against a retired employee, the service is deemed to be continued. Where is that? Must be deemed to be in service.
Otherwise, Rule 21 of the pension rules.
This is pension rules. Pension rules,
It relates to that departmental proceeding after the retirement, Lordship, that Rule 21 of pension rules, Lordship.
no, that is only when the governor reserves the right.
Lordship.
Unless the governor exercises the power to reserve the right,
Lordship.
or in the name of the governor, somebody does it. Yes. Anything in this Assam disciplinary appeal which where it is a deemed provision that the petitioner would remain in service? Is there any provision?
No, Lordship.
Manual of departmental proceedings. Manual for the-
Next, Parag. The learned standing counsel for the respondents could not refer to any provision under the Assam Services within bracket discipline and appeal bracket close rules of 1964 by which an employee public officer who is under suspension on a charge of misconduct and who attains the age of superannuation shall be deemed to be in service even after the age of superannuation for the specific purpose of continuation and conclusion of the disciplinary proceeding. Full stop. Therefore, comma, in the absence of such deeming provisions, comma, the disciplinary proceeding initiated against the petitioner must be deemed to have been terminated on 28/2/2009, on the day he is superannuated. Stop. Next paragraph. Nothing has been brought on record that the competent authority had passed any order under section 21 of the Assam Services within bracket pension bracket rules of 1969, reserving the right to withhold or withdrawal of pension or any part of it. Had such an order been passed by the respondent, the undersecretary to the government of Assam, Water Resources Department would have reflected it in the affidavit in opposition filed on 20/2/2013. Therefore, comma. Next paragraph, therefore, perhaps. The court is of the constitutional opinion that on superannuation of the petitioner on 28/2/2009, comma, as the respondents had not disclosed passing of any order to deem the petitioner to be in service even after the age of superannuation. And as it is not disclosed that any order was passed by the competent authority to withhold the pension of the petitioner, comma, for all intents and purposes, comma, the disciplinary proceedings instituted against the petitioner would deem to have been terminated on 28/2/2009, the date on which the petitioner is superannuated. Next one. Not next paragraph, same paragraph. Accordingly, comma, it is ordered that the disciplinary proceedings, comma, if any. No, the discipline, it was instituted against the petitioner. By issuance of show cause notice. Dated 11/12/2008 is deemed to have been terminated on and from 28/2/2009. Next paragraph. Resultantly, comma, the petitioner is also found entitled to an order of regularization of the period of suspension from the period from 28/8/2008 till 24/2/2009. And is on duty. And he will be entitled to all pecuniary benefits. Or any other consequential benefit for the said period. Full stop. Next, as the disciplinary proceeding against the petitioner is deemed to have been terminated with effect from 28/2/2009, comma, the petitioner will not be entitled to any promotion from the date his junior in the his juniors came to be promoted. Because till 28/2/2009 from the seal cover. The recommendation of the DPC in seal cover. Not have been open till 28/2/2009. Next paragraph. Accordingly, comma, the respondents are the respondent numbers 1 and 2 are back to calculate the pension and other retirement benefits of the petitioner as may be available and as will be admissible. In accordance with law. The retirement benefit, including pension, etc., shall be released to the petitioner within outer period of 4 months. Outer period of 4 months from the date of receipt of a certified copy of the order. Which shall be served on the Respondent number 2. I, the Secretary to the Government of Assam, Water Resources Department. Full stop. Next, the petition stands allowed to the extent as indicated above.
Lordship. Lordship, that seal cover, that will be open, Lordship.
No, now it doesn't give a benefit because it is terminated on 28/2. On that day, you don't get any benefit.
Lordship, that post of assistant engineer will vacant on 30/12/2008. During that time,
Whenever it is,
Lordship.
but your termination of the proceedings is on 28/2. The seal cover has, it can't be you can't get the benefit of anything in the seal cover. The termination is on 28/2.
Lordship, but if he is exonerated after the disciplinary proceeding, if everything is terminated, Lordship, if he is exonerated of all the charges, Lordship.
No, but
then
disciplinary proceeding still was there till 28/2.
it was
You
there,
are
Lordship.
getting the benefit of your retirement,
Lordship.
but we can't say that you have been honorably exonerated.
Lordship, that instruction I had, Lordship, that he was exonerated, Lordship, after his retirement, Lordship. It continued. But since nothing is in writing, Lordship, I couldn't place it, Lordship. I think
Receiving his pensionary benefits is receiving, Lordship.
In case of Janki Raman, Lordship, if he is exonerated all the charges, Lordship, then you get the benefits of those promotions, promotional post, Lordship.
Let me take an opinion. Mr. Nayak is there. Mr. Nayak. But take your independent opinion.
Lordship.
The man was under suspension. There was a disciplinary proceeding against him. There's no material on record to show that the disciplinary proceeding, any order was passed to extend his period of service till the department proceeding is concluded. So therefore, when he retired on 28/2/2009, we have held that the department proceeding has terminated on that day. So neither the governor has exercised power under section 21 of the pension rules to withhold the pension. Therefore, termination is on 28/2/2009.
On the same day he retired.
On the same day he retired, because it is deeming provision. Once they retired, they can't extend.
Lordship.
Assam Discipline Service rules, I don't find any provision where there's a power to extend his service till the departmental proceeding is concluded. Or even if it is there, nobody pointed out before me. That's one fact. Now, when the termination takes place of the departmental proceeding,
It
if he
means,
is entitled to promotion, what happens to that?
Lordship, on that date, his DP was terminated. On that day, he will be reinstated, Lordship. And there is
He was-
nothing found out in the DP, Lordship. DP is not there, and nothing, no punishment penalty was imposed against him. So DP was withdrawn, Lordship. It was dropped.
It is deemed to be dropped. So
Yeah.
he gets the benefit.
Yeah, in that case, Lordship, he should get the benefit.
Thank you.
If in the meantime, Lordship, Departmental Promotion Committee recommended his name and still cover the promotion, Lordship.
In the affidavit, they have stated that it was put under seal cover, Lordship.
Yeah, that's okay, but I was under the impression that once it is terminated, he doesn't get, but once Mr. Nayak says, I'll go by him.
If DP is not there, Lordship, then he is reinstated.
So therefore, consequentially, the department proceeding having been terminated on 28/2/2009, if there is no punishment imposed on the petitioner which prevents him to be promoted, the DPC recommendation, which was kept in seal cover, would have to be opened by the respondents authorities, respondent numbers 1 and 2. which we deemed to have been opened on 28 to 2009. And any benefit arising out of the DPC recommendation would be available to the petitioner on and from 28 to 2009.
May be counted towards the pensionary benefits as and when it is.
And accordingly, notional benefit would accrue to the petitioner for the purpose of calculation of his retirement benefit.
Only the notional benefit or benefit,
Notional benefit,
notional,
because
yes,
from that day when he retires, he get the full benefit,
Lordship.
but for that period, he will get notional benefit.
Lordship.
Time being item 11.
I'm going to put-
Yes.
My lord, may it please your lordship, my lord, yesterday, my lord, at about 9:30, Mr. Loskar, my lord, came to me, my lord, with this file to argue the case, my lord. Now, I said him, my lord, I told him that you do it. Because, my lord, they are also to do some cases where, my lord, becoming old, my lord. And, my lord, that's why, my lord, I have handed, you are competent enough, you do it. And in that way, my lord, I returned the file immediately, my lord. Now, another aspect, my lord, I will be unable to do, my lord. What happened, my lord? Yesterday, I took bath, my lord, in cold water. And today, my lord, today I have to come to this court, my lord, taking this antibiotic and all this. Everything is stopped, your lord. So, my lord, if he is not ready, my lord, some 1 or 2 days may be given to him, my lord, to argue. He will do it, my lord. They can argue, my lord. Everything I may not, my lord. I come, my lord, from Delhi, my lord, to do 4 or 5 cases, your lord. At least five cases I come, and I always try, my lord, to list these matters, my lord. Unfortunately, my lord, these are, my lord, not disposed of. And these are the, my lord, cases, my lord, for which I had to come. These are important, my lord. This case he can do, my lord. Here in this case, your lordship,
No,
what
we will
I
not
have
do-
found
we will not-
yesterday,
we
my
will not
lord.
keep it. What we can do is that once you make a submission, we can do is that we reserve it for judgment. And in the meantime, by day after tomorrow, written argument can be filed.
My lord, Mr. Loskar can argue, my lord.
Yes.
Oh. My lord, one batch comes, my lord, then goes. Other batches come up. So I have asked them, you also
definitely.
try something to do.
Definitely.
This is the thing.
So, Mr. Laskar, day after tomorrow, you file a written argument. But close this matter.
How like this?
Mr. Andor, and counsel for the petitioner has prayed for an adjournment.
আরোহণ 56 এ দেখানোর
This is a repetition of year 2012. On prayer for adjournment is refused. However, we permit him to permit him or his or his instructing or his assisting counsel to file a written note of argument within 2 days, which can be handed over to the court master positively within 17/5/2024. Matter is reserved for judgment.
Obliged.
Obliged.
Item 13 with 14.
Yes.
My lord,
May please, your lordship. Lordship, kindly matter may be possible for the day, lordship. This matter is dealing with Mr. M. Hussain, lordship.
no. My lord, may I just submit, this matters have already been dealt with by the honorable court. In fact, my lord, there's a judgment and there's an observation also. So before parting with the record, it may be mentioned that inclusive of the present writ petition, 7 writ petition being number 5454 of 2017, 3014 of 2015, challenging the same selection process were heard together. However, separate judgments have been delivered.
These are all disposed of.
Yes, my lord, they have been seeking time again and again on the. Dispose of it. Fully covered, right? A judgment. 3014. 3327 2007 is up. It is up. 7 represents 555. Disposition. 5454 of 2017. Okay. 3327. 17.
But where is the separate judgment?
No, that judgment has not been followed up. But however, this is a similar batch of writ petitions. My lord had decided same advertisement, same selection process. My lord may see at page 4 of the judgment. The advertisement is of 9/4/2013.
Just on. No, but this observation is incorrect. This. It is 3014. It has to be separated. This observation in this judgment is incorrect. You have to so to review it and remove this paragraph 21. You see, what has happened was it's a mistake on part of the court, and therefore we have no hesitation to admit that mistake. 12/5/2021, this court had issued a direction for the respondents to take fresh steps. Under the factual matrix, the petitioners are directed to take fresh steps within 11/6 for service of notice on the respondents, which is made returnable on 16/7. Therefore, the observation made in this judgment is a mistake. 3014 could not have been there.
My lord, may I just submit here, my lord? My lord, even if that observation of paragraph 21 have been come by mistake, my lord, but the facts and the net.
No, that is different.
My lord.
That is something else.
And they have taken steps after that, whatever my lord has
No, it's
placed.
okay, but this is a mistake on part of the court. Therefore, if I have committed a mistake, I have no difficulty in accepting it. Same order here. So these two repetitions has to be struck off. All sides are represented.
May I submit lordship? Also kindly it may be taken at two, matter may be disposed of in presence of Mr. Hussain lordship.
No, we'll have to call this record and have to alter it. We'll take it up at 2, but we'll have to recall this order. Which is the representative? Mr. S.P. Sharma then comes for the APDCL. Has produced a copy of judgment and order dated 12/5/2021 passed by this court in WBC 3327 of 2017. Post office. In paragraph 21 of this judgment, this court had made a mention that separate judgments have been delivered in WBC 5454 of 2017 and 3014 of 2015. WBC 3014 of 2015. Full stop. However, when on the perusal of the records of these two writ petitions, which are listed today, it is noted that by order dated 12/5/2021, directions were issued to the petitioner to take steps. The petitioners to take steps on several respondents. Therefore, comma. The inadvertent mistake made in paragraph 21 of the judgment and order dated 12/5/2021, passed in WBC 3327 of 2017, calls for a suo motu review of the said judgment and order dated 12/5/2021, passed in WBC 3327 of 2017, only in respect of observation made in paragraph 21, wherein it is noted that separate judgments are delivered in WBC 5454 of 2017 and WBC 3014 of 2015, and for no other matter. The registration is the sort of review tomorrow. Tomorrow is 15.
My lord, day after tomorrow. So
No, I think that there's a division bench on the day. We'll take it up tomorrow. This one. This two writ petitions is also listed on 15/5/2024. You are present?
I'm for respondent number 9, lordship, in
Also said
5454.
present. Also said, we have, all
We
sides
have
are
filed-
represented.
We have filed only affidavit, lordship.
No, it's okay. We have recorded, all sides are represented.
my lord, may I just submit, my lord, my lord, off the record, my lord, but what had happened on that day, when the entire writ petitions were heard, my lord had observed that this person's, these two writ petitions, they have not taken steps upon the private respondent. Accordingly, my lord, the matter was CAV, and when the order came out, the separate judgment had to follow.
No,
But-
But incidentally, you see,
Yes, ma'am.
as it is a mistake, then that's why this judgment was not tagged with these two records.
Yes, my lord, it does not.
Correct.
Yes.
So it is apparently a mistake of the court.
My lord, but the
Therefore, that-
entire facts is same.
No, the facts may be same, but that's something else.
My lord.
But the primary fact is that the observation in this You see, in a case, there cannot be two judgments. Correct.
My lord.
So once a judgment is not delivered in these two cases, and there is a specific order, directive steps to be issued, that means a mistake of the court.
My lord.
So far as I am concerned, I have no grievance or no reservations in accepting a mistake.
My lord, my lord.
Correct.
No, just
I'm not infallible to mistakes. Once I make a mistake, I have to own it up.
Item 15.
May it please your lordship.
My lord, in this matter,
Just a moment. Just a moment. I'm like to review this way too. Yes.
my lord, this matter, my lord, I was informed that this morning that my lord, my petitioner friend has some problem today and is seeking adjournment. Say that apart, my lord, even me also, WPTBC was just implemented on the last occasion, my lord. And I have sought for instructions, my lord. I'll be receiving the instruction by today or maybe tomorrow, my lord. That is what I am told from the department, my lord. So, my lord, though it's a 2016 matter, my lord, I was just brought in on the last occasion, my lord. So, my lord will permit me 2 weeks' time. I will complete this, my lord, the affidavit part, my lord.
You are challenging the
Appointments of
respond by 10.
6 to 10.
6 to 10.
Only thing is this, my lord, the advertisement notified vacancy was 6. And they were below, I am number 3 and 4 in the merit list. And maximum reservation was 22%. That means 2 posts. Now they have filled up 3 from the OBC, 1 from the STP, 1 from the STH. So it becomes more than 50%. The cases of the WPTC department is this, my lord, they have brought the backlog vacancies.
which was earlier carry forward. Whether it is permissible to go above the 50%, that is the
If
whole
it is
issue.
backlog, it is not counted.
It's not counted in the vacancies. That is there, but they are the main persons. But today only morning I've got the brief, my lord. So that much what I can go through it. Earlier councils has been elevated.
So what is your position? You got the instructions? No, Mr. Dhawal.
My lord, by tomorrow I'm getting it, my lord. Means it's done, my lord. What they do is they send it for vetting also, my lord. So by tomorrow I will have it, my lord. So my lord will grant me 1 week time, my lord. By then I will, whatever instructions I will, in a form of affidavit, I will file it.
Also, it's a represented. Mr. R. Dhawal, learned. Yes, R. Dhawal, learned. Counsel for the Department of Social Justice and Empowerment.
No, my lord, it will be tribal affairs, my lord. Social justice and
Tribal
empowerment.
affairs. No, last time you made a submission.
Yes, my lord.
According to Mr. Dhawal, the present matter would come within the domain of Department of Social Justice and Empowerment. Because
Social justice and empowerment, then my lord, RM Das has to come in, my lord.
I don't know.
My lord, it's trifurcated, my lord. That's the problem, my lord.
My difficulty is that when I say something, I am backed by something.
Thakuria is OBC. OBC, no, my lord, RM Das has to come in, my lord.
You
So
speak
it-
last order.
I remember, my lord, that water, my lord.
You remember something which happened 11 months ago?
My lord, I saw the order, my lord. That is what, my lord, I said the sending council tribal affairs department. I appeared for the.
No, but there's difficulty again. You see, response number 10 is ST Hills.
Yes.
Earlier, my lord,
No, that I don't
WPDC
know.
was
Just-
one department, my lord.
I'm just telling you, response number 10, I saw incidentally that he or she is ST Hills.
Hills.
I did not apply my mind for the others.
I will file it, my lord. Any, the instructions coming, my lord, whatever it comes, I will file it. Let it.
No. Don't say that. You see, if it is social justice, if some other council is there, you can't take the responsibility. You just
My lord, then I have to go, my lord.
you call him and decide. In the meantime, I'll take a break.
My lord.
In the meantime, you decide and tell us. At 2 o'clock, we'll pass orders.
My lord.
You consult with,
Department in, I know, yeah.
because this respondent number 6 to 10, who they are, I don't know. Only 10 incidentally, I saw that ST Hills. Others, Mr. Rajade will tell him. Who are
Three
those
are
two that-
OBC, one is STA.
Just tell him, I don't know.
3 are OBC.
2.
I'll file to WPT and BCA.
I think so the problem WPDC department in, I know, fine, the department is having, yes.
Division bench item 1 to be spoken to. Criminal Appeal 298/19.
There appears to be a typing error in the name, so we are correcting that.
That is what I thought, the judgment is already delivered.
Ha. No, I'm speaking to
Not.
Sister. Sister, you are getting the voice?
Yes, I'm getting your voice.
There is a, this has been listed at the instance of the counsel for the petitioner, as there is a mistake in the cost title, only that much. The
Okay, I didn't realize that. In the
Ah.
cost title.
the district for appellant number 1, it should be Hojai, I, it is L.
Okay, yes, okay, it's,
And then there's, and then in the number 2, it is Murajhar, D is extra. Spelling, in the spelling Murajhar, PS Murajhar,
okay.
D is extra.
JHAR, okay,
Yes.
no D, okay,
Ah.
fine.
And in respondent number 2, son of late, the village name has come.
Oh, okay.
The cost title we have communicated is in the next page. It is the son of late Samsuddin. I'll make that mail that
Yes,
spelling.
yes,
again.
please do that. No, we didn't know all these little
Late
details.
Samsuddin. So that is the only correction.
Okay.
And this the IA number will have to be struck off because IA is already disposed of.
Okay.
So this one things I have to notice. So you make the correction.
Lordship will remove the judgment already posted in the website or?
No. Let that remain, but this is a fresh order. It will be read together. Because we don't know, since it is in public domain, who might have downloaded it. So.
This will be an added order. Addition.
Yeah, it's an additional order. This heard Mr. H. Chaudhary, and counsel for the petitioner, sorry, appellates, and Ms. S. Jahar Lanet, AVP for the state, respondent number 1. Next paragraph. This matter has been listed at the instance of the learned counsel for the appellants, who has pointed out that some inadvertent typing error has crept in the cost title. First of the it is pointed out that in the cost title, the reference to the interlocutory application may not be there, as IA criminal 642 of 2019 has already been disposed of. So this is one B. In respect of appellant number 1, the spelling of the district should be Hojai, which is inadvertently spelled as HOJAL, Hojal. Number C, in respect of the appellant number 2, the correct spelling of the police station is Murajhar, Murajhar. Which is wrongly spelled as Murajdhar.
Okay, those which we didn't notice, yes.
Next, in respect of respondent number 2, he is the son of late Samsuddin, SAMSUDDIN, which is wrongly recorded as son of late Dakhin Laskar Pathar, which is in fact the name of his village.
Okay.
Stop accordingly, the cause title for respondent number 2 would be as follows. Harish Ali, son of late Shamsuddin, resident of Dakhin Laskar Pathar, Yes Lanka, District Nagaon, Assam, pin 782446. Next para. The correction. uh, full stop. Accordingly, corrections are made in the cause title of this,
But it is I only.
of the judgment and order dated 24/4/2024, passed in the connected, passed in this criminal appeal number 298 of 2019. Stop. Next para. This order shall be read together with the judgment and order dated 24/4/2024, passed in criminal appeal 298 of 2019. That's all, sir. All right.
Online.
Time being item 15.
My lord, what I found is now they will have to implement tribal affairs planes also. Was 1, 3 OBC. STP.
Mr. Nayak is the only one smiling.
No, this is the same order, Lordship. In one list, 6 names are there. One
No, that's
belongs to
okay.
STP, one belongs to OBC.
That's okay, I'm only observing
Whoever
that.
takes out that list, Lordship, other name will automatically come, Lordship.
My lord, my difficulty is that the WPDBC department as of today doesn't exist from 22. So what I can do is I can bring in the document on affidavit through tribal affairs department. Same document. I can bring it on record matter. I can bring that. Only the problem is that, my lord, that
No, for effective orders, I'll have to implement, otherwise there will be some difficulty later on.
my lord,
Is
I
it
can
not?
bring in that
No,
document.
that's okay. But to, supposing
Yes, my lord, that is there.
supposing we accept the contention of the petitioner, then what?
Exactly, my lord.
Yes, Mr. Nayak, what do you say?
Lordship, a select list was there that was forwarded to the WPTMDC department for their approval. They say that already more than 50% general category candidates are working. So let this post be filled by reserve category post. That is their approval, and it was followed by the PWD department, and accordingly persons were appointed. So names are in the same document, Lordship.
Then
No,
I can bring
I
out.
understand, there's no difficulty in that. But what I'm asking you is, let us assume for the time being that the judgment will be favorable to the petitioner. Correct. We don't know what will happen, but let us say that it happens. Then whether in the absence of those 2 other sub-departments, can the order of the court be implemented? That's the question. Huh?
He can represent one department, he will represent the other department. And now it has been bifurcated, trifurcated.
Huh.
So one, he will represent, the other, he will. represent.
That can be done. Okay. Mr. P.K. Roy Chaudhary, Learned Counsel for the, Learned Counsel appears for the petitioners. And it is submitted jointly with Mr. R. Dhar, and Standing Counsel for the
Tribal affairs planes.
for the Department of Tribal Affairs, within bracket plain, that after the WPT and BC department has been trifurcated, comma, 3 departments have come into existence, being the Department of
Tribal Affairs Plane,
Tribal Affairs, within bracket plain,
Social Justice and Empowerment,
comma, Department of Social Justice and Empowerment,
and Bodoland Welfare Department.
comma, and
Bodoland Welfare Department.
Bodoland Welfare Department. So hence it is submitted that the petitioner will take steps for amendment of the cost title. Full stop. Next para. Mr. Sri Sharma, the Council of the Social Welfare Department, and Mr. P. Nayak, learned standicals for the BTC are present. PWD are present. Full stop. Matters is adjourned today. List. How much time?
At least 2 weeks, man.
List after 2 weeks, as and when the application for amendment of cost title is filed.
Can it be by hand, madam?
Yes, you can permit that by hand also. You can permit it by hand.
No, my lord, there is a notification of the honorable court.
No. That will be by type copy, but it can be done without an application.
Correction. My lord, again, it is uploaded in the system, so I can,
That will be done.
then if it is, my lord, then
So then amend this order. So you say that in view of the nature of pyramid, comma, the taking note of the trifurcation of the WBC and BT department, comma, the court permits the land council of the petitioner to amend the cost title of this petition by submitting a type copy of the cost title to the AOJ civil pending section. Stop. On receipt of the same, comma, the amended cost title shall be incorporated in the rate petition, and steps shall be taken for amending the central registry of the court in respect of this rate petition. Next para. The learned counsel for the petitioner shall also provide the amended cost title to the learned departmental counsel appearing for all the respondents.
What about the?
List after 2 weeks, as and when the corrections are made. Okay.
Production list item 1.
Check. An officer,
Just a moment.
Gramin Vikas Bank.
Just a moment. Where is the order of this court, previous order?
That it starts from page 14, your lordship. The relevant portion is at page 18. It starts from third line, your lordship. It is hereby directed that the petitioner shall file a concise representation giving all the details of his grievances against the impugned transfer order to the respondent number 2 within a period of 15 days from today, and the respondent number 3, and so on, so on. That was done by me, Your Lordship, that my representation starts from page 19, Your Lordship. The main issue for which I wanted to be in the same station in Lordship is that my wife is suffering from a very rare disease that is called myasthenia gravis. It is a very rare disease, Your Lordship.
Myasthenia is not a serious, unless,
Autoimmune disorder.
no, it's not autoimmune. Myasthenia gravis is a condition where the muscles die.
Yes, that is why it is called, it is included in the list of autoimmune. Progressively.
So,
But
but,
I'll leave
but
it-
Mr.
I'll-
Sharma,
I'll,
you are there in this place for how many years?
I am about 3 years now, Your Lordship. I admit that, Your Lordship, that
How many years? Total tenure in this region, how many years?
in this region, I joined in October 21, Your Lordship. In this region, I am from 30th of October 2021, Your Lordship. And it is now 24. I'm in this region for 3 years only. And as per the rules of the bank, Your Lordship, that is at page 47, Your Lordship. The last column, last item, Your Lordship, Roman 5. 2 tenures of 3 years is the period for which one officer can stay in a region, Your Lordship. Furthermore, Your Lordship, my sister is also suffering from cerebral palsy. And my father is also a heart patient, Your Lordship.
Page
All this-
37, the medicine given to you is the only medicine. I may not prefer number 2, but number 3 is the only medicine for this for this myasthenia gravis.
But she requires constant medical attention, Your Lordship, because her condition is very serious, Your Lordship. And
If I'm saying so many things, that means you must presume that I know something about myasthenia gravis.
moreover, Your Lordship, my wife gave birth to.
What is the disease of your wife?
Lordship,
Where is the disease of your wife?
that is at page 27, Your Lordship.
27.
27. Yeah. Diagnosis.
This is myasthenia.
Myeloma with myasthenia gravis.
Who is the
That
other
is
patient in your
from
house? Your father.
Gangaram Hospital.
Where is your father's document?
Father.
This is wife. Your
His
father is
wife
also ill, you said.
Father's
Where
document.
is his medical
Page
document?
23.
23.
Lodge.
And my sister's event is at page 44, Your Lordship. That is an identity card issued by the Social Welfare Department regarding the disability she is having, Your Lordship, cerebral palsy. Molecular version is at page 44, Your Lordship, and 45. The English translated copy is at 43. Therefore, Your Lordship, at least for the mandatory period of 6 years, I should be kept in this region, Your Lordship. Because if I be in this region, it will be convenient for me to attend my wife and my ailing father and my.
Where is the transfer policy?
That is at page
46.
46. It starts from 46 and relevant portion is at 47, Your Lordship.
47.
47, Your Lordship. Down below, item 5, Roman 5, Your Lordship.
But Mr. Sharma, you see, it's a well settled position that once a transfer is passed, you may accept it, but you'll have to accept the transfer. But the interim stay it cannot be granted because the Supreme Court has come down heavily on the stay of transfers. You see that you have to. What is the name of the judgment?
Right from SL Abbas, there are so many.
A Abbas,
SL Abbas.
SL Abbas, huh?
SL
Right.
Abbas.
Hmm. After two tenure of 6 years in one region, officer will be transferred to another region.
I'll be in great difficulty, Your Lordship, if the
Yeah.
regional transfer is effected, Your Lordship. At least for some time, Your Lordship, I may be kept in this region, Your Lordship. So that the condition of my.
Where is that condition? Page 47, which clause you are
Five.
referring to?
Five, Your Lordship. Down below, Your Lordship, 5.
After posting of two tenure, which is 6 years in one region, officers will be transferred. What is your,
I am 3 years now, Your Lordship.
no. The 6 years will only be for D12. D12 is officers having special professional training, proficiency, qualification in law, treasury management, account credit, etc., whose posting may be extended beyond 3 years. So you must be, for 6 years, you must be D12. What is your qualification?
I am the branch head, Your Lordship. That
No.
the one, the branch, Your Lordship.
Yes, Mr. Ganguly, why cannot be?
In this case, there are two, three crucial aspects. One aspect is that, going through the medical documents of his father, because father and sister, as per the transfer policy, are not covered. The wife would be covered, but there is a specific category of illnesses which is mentioned in the transfer policy itself.
Where is that?
That list of policy diseases, Lordship will find at page 48.
48.
Yes, there is a note, my lord, which is appended under
Yes.
the rules under compassionate ground. So I must say, my lord, that this comes under the heading of request transfer, and this is not a case of request transfer. This is a rotational transfer, which Lordship was just seeing in the other page. Be that as it may, my lord, as far as this note is concerned, para A, diagnosis of terminal or critical illness for self, spouse, or dependent children. Type of diseases to be covered: cancers, paralytic stroke, renal failure, coronary artery disease, thalassemia, Parkinson's disease. Such transfer requests will be considered only within 1 year from the date of first diagnosis of illness covered as above. So here, my lord, the category of illnesses, even in respect of, my lord, the officer himself or his spouse or his dependent children, this is only these 5, 6 are mentioned. And my lord, these requests are, of course, in the category of transfer requests. He has not requested, this is a rotational transfer. That apart, my lord, his wife is admittedly herself a surgeon. His wife is a surgeon. She's a doctor herself. And my lord, as far as the father is concerned, my lord, upon going through the medical documents, we find that his father had CABG, my lord, coronary artery bypass, way back in 2006. 2006, another operation in 2008 also. But taking as a whole, my lord, he's in Dorangiri branch, which is more than almost 200 kilometers almost away from Guwahati, which is his home region. Lord, in the exigency of service, Lordships, my lord, I did not remind, my lord, it's an incident of service. Now, this type of, my lord, aged parents, my lord, so many officers are there. We have received a spate of representations. It's very difficult to accommodate, my lord, particular officers like this. And in his particular case, my lord, even the hearing was held. If I may just hand over, my lord, the proceeding that was pursuant to this court's order, my lord, when the petitioner appeared. So these are the proceedings dated, my lords, 26/3/2024. I'm sorry, my lord, this is dated 4/5/2024. The representation was 26/3.
Is it? That the- Okay.
And all the documents were not medical documents of the wife, which my learned friend was referring to. Every single prescription is written no fresh complaints, no fresh weakness. And medication, this is something which will require constant medication. But this does not mean that he has to be necessarily. The numerator is written that she requires constant supervision or medical attention. Every this diagnosis, every prescription says no fresh complaints, no fresh weakness. And herself a surgeon, so the best person to take care of herself.
Just medication is a very dangerous thing, whether he is a surgeon or a medical officer. It is a very dangerous thing, not. You cannot take care of oneself. That is switchable. Now your appendicitis operation, and she has been consulted one surgeon from laparoscopic surgeon from Guwahati, who is going to undertake the surgery. Your lordship. But date has not been fixed yet. They went to the doctor on 1st of May, your lordship. At page 42. And she was under consultation after 10 days for because of surgery and all. However, your lordship is my sister is also cerebral palsy patient, your lordship.
Mr. Ganguly, I think you can give him 6 months extra. If she has undergone surgery with myasthenia gravis, I think she needs.
No, surgery of that related to myasthenia was done in November 2023.
No, myasthenia.
It's already 6 months. It's already 6 months since the operation.
No, the appendicitis is now. She is suffering from myasthenia. Myasthenia is something which can't be cured.
Yes.
Correct.
That is.
The deliberation in the court will make you understand that I know something about myasthenia
I
gravis.
understand.
I know a lot more which than I'm speaking. Now, myasthenia gravis is something which can't be cured. It's irreversible. It's a muscle wasting disease, and therefore, any trauma to any muscle may lead to its death. Correct. So even a surgery if done for a patient suffering from myasthenia may lead to a complication which we may not know right now.
Yes.
So if page 42 shows that she has undergone appendicitis, this has been operated.
Not yet. Not yet.
then I think she would be needing it.
But for that particular period, Lordship may observe in the order that he will be entitled to, because my lord, he can always take leave. I think it's not there that my lord, for that, the transfer should be my lord extended 6 months. That perhaps would be my lord setting.
I was
Not a
informed by,
proper-
I am told.
For that
Lordship,
period, my lord, he can always seek leave, and that leave shall be granted, my lord, because that is always there for every bank officer, my lord, because everyone has family and operations are there, my lord. These are part of life. But on that ground, my lord, because otherwise it would send perhaps not a proper, my lord, precedent. Even if he wants extended leave, my lord, for that period, he can always apply that.
Why, if you can stay, if you can stay in the locality and then have his wife taken care of.
Look, Silchar to Guwahati, he can always come by
that
flight
it
also.
is about 18
Or
hours journey.
Silchar
from
to,
Kolkata.
if he is going to
To
Silchar.
take care of wife, no, it's asking for something which can be done. You may not know the trauma of people who are
I have
bedridden.
no personal.
Both my parents were bedridden. My mother was bedridden for 9 years.
Lordship.
So staying few days here and there in Kohima or Mizoram or Itanagar did not cause any problem. But to have a long tenure would definitely cause a problem. There are many judges who have suffered this. Honorable Justice Ujjal Bhuiyan, he suffered. His parents were both unwell.
Or I may take
You please,
instruction on
you
this
please
part.
take
perhaps,
instructions, we'll take it up after some time. In the meantime, you take instructions. Give a phone call and then take instructions.
I'll try. Or if it can be taken up tomorrow, perhaps.
Tomorrow again, there are a lot of matters which are already listed.
I'll try.
Just try to have a word. Because leave is something which can be taken. He'll also get leave can be taken, but if
No,
it
so
can't
I
be
told
approved,
that he has exhausted all his leave here also.
he's
He
your
doesn't
staff.
have any leave at his credit.
Just try to find out.
I'll try.
Or there may be some other reason for which maybe they are not penning it down, but there may be some other reasons also.
Yes,
Just try to get
I'll
that.
try to find. Lordship is indicating 6 months.
I think that would be enough. Because if it's an appendicitis with myasthenia, it'll take him at least 2 months to be restored back to. 2 months is a.
For a period
is
of
a
1
requirement.
year, probably your
2
lordship.
months is a medical requirement.
I'll try to.
Correct.
Lordship may consider for a period of 1
I'm not
year.
considering anything. We'll ask the officers to
I'll take
consider.
instruction. I'll come.
Time being item 6 with 7.
Yes. Maybe also. Look, the issue involved is basically herein is promotion to the post of principal diet. We have challenged a DPC minutes dated 7/7/2023, by which the respondents, they made an attempt to promote some underqualified senior lecturers to the post of principal diet. And this honorable court was pleased to pass an order not to promote the underqualified senior lecturers. And subsequently, you know, 2 of the persons who were recommended by the DPC, they, you know, raising a grievance that they were retiring they approached this honorable court by filing IA Miller for modification of that order and allow them to hold the post of principal. And this honorable court subsequently was pleased to modify the initial interim order to an extent with some riders, my lord, that whatever the promote, they will be allowed to get the promotion, but ultimately the outcome of the review.
You are following for your promotion, you are following the this 2010 rules.
Sorry, my lord.
For your promotions, you are relying on 2010 rules.
Yes. My
There is a
contention
copy.
is that NCT guideline, NCT regulations, NCT regulations of issued by the National Council of Technical Education 2014, that has prescribed the qualification for the post of principal. And overlooking the NCT regulations, the respondents made the move to promote. I'll just take.
Where
your
is the
lordship
diet
to-
rules? Where is the diet rules?
Diet
2010?
rules, lordship will find page 99.
99. But Mr. Das,
Yes, please.
page 99 is not here.
Lord, P17, annexure P17.
Last page in this 4963 is page number 84.
49, 4255.
Page 99 of 425.
4255 kilo WPC.
4255.
425. Yes, ma'am.
But please tell me, Mr. Das,
Yes, my lord.
rightly or wrongly,
Yes,
there's a rule in existence,
yes,
which is Diet Rules 2010.
yes.
If you say that the NCT rules will override, then you'll have to challenge that rules. Unless that rule is under challenge, we can't give you relief.
No, my lord, rules doesn't, Diet Rules 2010 does not provide for qualification for the post of principal. But NCT regulations of 2014 provided qualification for the post of principal, my lord. And that NCT regulation, my case is that the NCT regulation is binding upon the respondents.
No, it may be binding, but they have a rule. Somebody will
And,
have to.
and they have taken a decision in one of the DPCs. They have taken a decision. If I place the papers before your lordships, my lord, perhaps, my lord, I'll be able to convey to your lordships, my lord.
Yes.
Already they have taken a decision in respect of lecturer, my lord. I'll just place the documents, my lord.
No,
My lord, the
so see,
petitioner,
I don't know, because I wanted this because since I can't remember pages and all, you see, come to page 100.
yes, my lord.
Page 100, clause 5, this of the rules, rule 5 says,
Yes,
recruitment, so the
Shall we make
principal.
in the
The
manner,
post of
yes,
principal shall be filled up by promotion from the select list of vice principal. This is the prescription.
yes, senior lecturer, having not less than 10 years of experience as lecturer
So,
and senior lecturer or vice principal.
so you see, if we have to adopt, if we have to take a, you see, number one, we are not called upon to take a call as to whether this rule is in contravention of the NCT rules. So if this rule prevails, then the action of the respondent authorities in making an appointment in accordance with this rule 5(1), we cannot say it is wrong. Number two, if the prescription of NCT prevails, then there has to be a declaration that this will override. In
Lord,
the absence of a declaration, that was the query. That's why that's why I put
Diet
this
is
very
not
first.
the creature of the state government. Diet is entirely the creature of the central government. If the NCT regulations are not followed by the state government,
No,
then a
no,
case
no,
of
no, I don't know.
repugnancy
This
comes.
this is something which has come up in Assam Gazette. So it can't be that there's a agency, the central government agency, and the state government is making a rule for service. That is something which is privacy not acceptable. Despite this first this question. Now you may present your case in the manner you want.
Yes, my lord. The petitioner before your lordships, she is a MSc in geology, MEd, diploma in creative writing from KKHU. She has completed her PhD. Page 36, if your lordships kindly turn.
Page
36, my lord. Her initial appointment. This is
No,
the.
those things you don't require. There's nobody disputing those. Nobody is disputing
just-
an appointment and all. Your qualifications and those things are not being, I don't think, Mr. Chaudhary, you are disputing that.
There is no.
My lord, if your lordship would kindly permit me one thing.
No,
There is already a judgment where this honorable court says that this post will be filled up under the 2010 rules. There's a judgment, please
No,
come to
that's okay.
148.
I'm just trying to
Yes.
ask that his qualification of that, those we are not challenging.
No.
We are only in the crux of the matter, whether it can be promoted or it can
My
be
lord,
given.
his case is very simple. NCT prescribes a qualification which is not incorporated in the rules. Therefore, how come you are making this selection? But my lord, there is one more hurdle which my learned friend will have to overcome. Or see, when it comes to promotion, there's a concept called, my lord, zone of consideration. Now, my learned friend's client cannot have any grievance that he is in the zone of consideration. And secondly, my lord, this prescription is regarding B.Ed colleges, not DIET. The NCT guideline is also in respect of B.Ed colleges. The notification which they have annexed that itself shows. Please come to.
No, let him.
Yes.
Let him make his
Yes.
presentation.
Then I'll just.
Because
keep-
we all, otherwise respect you for your. But they must also get a chance.
Then I'll directly take your lordships to the promotion order of the petitioner to the post of senior lecturer. That your lordship will find.
There's
page-
also a reason, Mr. Chaudhary, to stop you. Do you know why?
No, why?
No, there's another reason I should tell you. Because we must hand over the mental to the next generation, no?
Correct. That's more important.
That's more important.
Page 88 is the order, my lord, by which the petitioner was promoted to the post of senior lecturer.
Yesterday, honorable, I had an interaction with an honorable former Supreme Court judge. And he said something which struck me. He said that being engrossed in the work for so many years till I attained the age of 65, after superintending, I came to know that I have grown up to the age of 65. So when you are working hard, you don't feel the age. And only after that.
Maybe during that time, there is no time to think also. What is the.
So he said that I found out only after my retirement that I have grown in age.
Correct.
Yes.
Page 88 is the promotion
88.
order of the petitioner, ma'am. This is dated 30/5/2023. The name of the petitioner at serial number 44. So she got promotion to the post of senior lecturer.
Yes.
Now lordship can turn to the rules, my lord. Service order, my lord. Assam District Institute of Education and Training Service Rules 2010, page 99. Lordship will kindly come to Rule 5. Rule 5, Rule 5(1), Roman 1. My lord, prior to that, lordship will also mark one date, that is 29/2/2008. That is the initial appointment of the petitioner as lecturer in diet. This will be relevant. That's why, my lord, I am praying for recording this date. He was initially appointed on 29/2/2008 as lecturer of diet.
29/2/2008.
2008, page 40.
Yes.
Now, if your lordships, if I read the rule, my lord, principal, the post of principal shall be filled up by promotion from the select list of vice principal, senior lecturer, having not less than 10 years of experience as lecturer, stroke senior lecturer or vice principal. So the requirement of the law is that, rule is that, my lord, one has to complete 10 years of experience as lecturer or senior lecturer. So having been appointed in the year 2008, I have completed 10 years of experience as lecturer. And that's how, my lord, the petitioner comes into the zone of consideration. Now, your lordship will come to the NCT regulations, my lord.
Yes.
Page 113. my lord.
113.
Yes, my lord, Annexure P18. This regulation came in the year 2014. Lordship Scotland.
113. Yes.
113. my lord. It says norms and standard for Bachelor of Education program leading to the Bachelor of Education B.Ed degree. Now, the relevant portion your lordship will find at page 116. The qualification prescribed for the post of principal.
This page 113, what is it?
This is, my lord, NCT regulations of 2014. This is basically Appendix 4. Right hand side, your lordship has seen Appendix 4. Just above the B.Ed degree, my lord. So this is
NCT regulation?
2014.
Yes. Yes.
It provides for the norms and standard for Bachelor Education program leading to Bachelor degree of Education B.Ed degree. So it provides for the norms and standards for the B.Ed. Now, the relevant portion of this Appendix 4 is at 116.
Yes.
5.2, my lord, qualifications.
Yes.
The faculty shall possess the following qualifications. Faculty means faculty in B.Ed institutions. Principal HOD, the qualifications are postgraduate degree in arts, science, social science, humanities, commerce with minimum 55% marks, and number 2, M.Ed with minimum 55% mark. Number 3, PhD in education or any other pedagogic subject offered in the institution. And number 4, 8 years of teaching experience in a secondary teacher education institution. Desirable is diploma, degree in education administration or educational leadership. My case is that, my lord, the persons who were recommended for the post of principal by the DPC doesn't have this M.Ed with minimum 55% mark and PhD. There are only, my lord, 7 persons seven senior lecturers are there. I'll mark those names below, who have a PhD. Now,
He is a principal faculty.
principal of Milord,
Can
Milord,
he sit
I'll
in the
just
faculty?
explain one thing. Milord, NCT doesn't provide for a particular institution. NCT provides the norms and standards for a particular course, like B.Ed course or M.Ed or like that thing. Now, these institutions having imparted B.Ed course, they are duty bound to, Milord, follow this qualification for the post of principal. Because diets are imparting B.Ed and D.Litt both.
Okay. Yes, okay.
Now, in the year 2017, precisely, Lordship will kindly come to page 122. The NCT issued another notification dated 29th of May 2017. It provides, Milord, in exercise of the powers conferred by subsection 2 of section 32 of the National Council for Teachers Education Act 1993, the National Council for Teacher Education hereby marks the following regulations further to amend the National Council for Teacher Education Recognition Norms and Procedure Regulations 2014. So this is an amendment to the 2014 regulations.
Yes.
Now, by this 2000, initially the NCT provided PhD and M.Ed with 55% mark for the post of principal. Subsequently, Milord, for the post of lecturer, which is the feeder post, the junior most post, by this notification, Milord, for the junior most post also, PhD and M.Ed with 55% mark was made mandatory. That your Lordship will find page 123, serial number 8. Now, your Lordship will kindly come to page 124, or Lordship will directly come to the original one, page 126, Milord. Lordship's got, Milord?
Which page?
Page 126.
Yes.
This was a communication from Director SCERT Assam to Principal Diet CTE ASC Normal and BTC. Subject is regarding conducting B.Ed D.Litt course for working days and adaptation of curriculum, etc. So local body herein, that is SCERT, it writes a letter to the principal of Diet CTE IASC Normal and BTC. Milord, it says, with reference to the subject cited above, I have the honor to state that as per the minutes of the 48th General Body Meeting of NCTA held on 5th February 2019, has decided few important decisions in teacher education institution may like to take action as follows. The GB of NCTA has recommended for 180 days in the line of UGC in a year excluding vacations, holidays, examination, my lord, this is not relevant. Para 4 is relevant, my lord. Lordship's got, my lord. Page 126.
126.
Yes, my
You
lord.
have with the
Lordship is there. I'm sorry, my lord. Para 4, my lord. NCTA has issued notification dated 29/5/2017 that I referred, my lord, just short while ago, the notification at page 122. With reference to that notification issued by NCT at page 122, this communication was issued. So NCT has issued notification dated 29/5/2017, where PhD degree in education or any pedagogy subject offered in the institute with effect from 9/6/2017 for fulfilling the qualification, the candidate shall have cleared the national eligibility test conducted by University Grants Commission, provided candidates who are or have been awarded PhD degree in education in accordance with the University Grant Commission minimum standard and procedure for award of PhD degree regulation 2009 shall be exempted from requirement of clearing the NET for appointment as assistant professor or equivalent position in university or college or institution. The NET slate PhD of assistant professor can be any pedagogy subject or in education for teacher education with effect from 1/7/21 for requirement of assistant professor lecturer. This is important, you know, the principal and faculty members of DIET, CTE, ISC are therefore requested to fulfill the requirements as mandated by NCTE for conducting B.Ed courses. So there was a request and made for fulfilling the requirements provided by NCTE for conducting B.Ed courses. Now page 127 is the notification issued by the government of Assam with regard to the post of lecturer, wherein they have included this M.Ed with 55% mark and PhD. It says, my lord, whereas education being the subject of concurrent list and NCTE being the statutory body of Government of India for teachers education has prescribed norms for teacher education courses as well as the qualification of teacher educators as per NCTE norms and standard. Most of the fund in this regard is being borne by the Government of India for conducting teacher education program sustaining NCTE or reorganization. Keeping above in view, the Government of Assam is pleased to revise the existing minimum qualification for all categories of post of District Institute of Education and Training, DIET, Government BT colleges, Colleges of Teachers Education, CTE, and State Council of Educational Research and Training, SCERT, as per norms and standard prescribed by NCTE as follows. So for the post of lecturer, serial number 1, your lordship will find they have provided A Roman 2, M.Ed with specialization in arts, science, social science, humanities with 55% mark or its equivalent grade. Number 3, NET slate PhD from any recognized university. So for the feeder post of lecturer, my lord, the Government of Assam has incorporated the 2017 regulations of NCTE and have made the changes in their qualification. Initially, this was not there in the service order, my lord. But so far as post of principal is concerned, in 2014, NCTE had said that you incorporate PhD, my lord, NCTE provided that qualification for principal has to be PhD in M.Ed with 55% mark. But they're sitting tight over the matter. Now, Lordship will kindly come to page 141. Lord, there is one significant consequence of this not following NCT regulations. Lordship is aware the NCT is the regulating authority for all the training education institutions, my lord. They have the power to de-recognize also if their, my lord, prescriptions are not adhered to. Now, in Assam, my lord, there are diets wherein, my lord, B.Ed, D.Lit, both are imparted. And there are diets wherein only D.Lit are imparted, training their course. Now, there is a instruction that now onwards, my lord, the government is making an effort that in all the diets, both these courses will be imparted, my lord. Now, if they don't fulfill the qualification for the post of principal, as, my lord, directed by the NCT, today there may not be any, my lord, casualty, but in the long run, that casualty will be there. And another aspect is that Lordship will appreciate a situation now that the post of principal, a person who is holding the post of principal, his qualifications are below than a person holding the post of lecturer. That is also a sort of anomaly that is, my lord, occurring now. Now, in the year 2021, the respondents have held a DPC.
Just like here, an ordinary LLB is looking at qualification of a PhD.
No, here, my lord, we grow by the practice, my lord. We don't.
That's okay.
We don't grow by our.
But the malady is that if you go by the degree, then perhaps the examination which I am doing will be beyond my
That's true, my lord.
educational qualification.
Profession is, my lord, extremely dynamic and yes.
Yes.
Page 141 is the, my lord, minutes of a DPC meeting. This is dated 4/2/2021, my lord. Due to typographical error, it was recorded as 4/2/2022.
Page?
My lord. Page 141. This was for the post of principal under diet. What decision they have taken at that point of time and how they have deviated now, that I just like to point out to them by these DPC minutes. The government, the respondents very well knew that NCT regulations are mandatory, but only to facilitate, they are not implementing it. And as a consequence, my lord, the PhD holders who have done their PhD are not getting promotion. Now, if you receive minutes of the meeting of the Departmental Promotion Committee held on 4/2/2021 at 3 p.m. in the office chamber of Commissioner and Secretary of Government of Assam, Elementary Education Department, Dispur, in connection with filling about 18 vacant posts of principal of diet under Directorate of SCRT Assam on promotion basis. Now, I'll just read the fourth paragraph, my lord. The para starts with the committee. The committee also discussed regarding the essential qualifications required for the post of principal. As per new guidelines of NCTE New Delhi, an eligible candidate for the post of principal diet must possess PhD degree. However, in WPC 2293/2019, Jasimuddin Sheikh versus State of Assam and others, the Honorable Guwahati High Court has in its order dated 9/4/2019 directed that Commissioner and Secretary of the Government of Assam Elementary Education Department shall fill up the vacant post of principal in diets of Assam, including diet Gwalpara Dudhnoi, by following the provisions of the said 2010 rules at an early date. Thus, the Honorable
High Court directed the government to follow the Diet Service Rules 2010. As the Diet Service Rules were notified prior to the framing new NCT guidelines, the requirement of PhD degree was not mentioned in these rules as an eligibility criteria for the post of principal. Considering these aspects, the committee decided to issue a notification relaxing the eligibility criteria mandated by NCT, however, as a one-time practice only. So government very well knew that NCT guidelines are mandatory, we are to follow it. And in this DPC, they have taken a decision that as a one-time measure we are doing. Now this contention that in WBC 2293/2019, the Honorable High Court had given direction to the respondents to follow the rules of 2010, it's absolutely fallacious. I have annexed the judgment of this Honorable Court passed in 2293/2019. There was no such directions. The members of the DPC Millard took a handle from that judgment and incorporated the proceedings as if the writ court in that particular writ petition, Millard, has directed that you don't follow NCT regulation, you go by service rules of 2010. That judgment I have annexed. I'll read that judgment. So this was the understanding of the respondents that as a one-time measure, we are doing it without insisting for the qualification prescribed by the NCT for the post of principal. And most ironically, this qualification came in 2014. Till they are not doing it. Now, I'll take your lordships to page 143. That is the judgment relied on by the DPC in the previous page. Page 143. Look, 4 pages judgment, I'll like to read the entire paragraph so that I can show to your lordships that there was no direction in this order to follow only service rules of 2010 for giving promotion to the post of principal. Page 144, it starts. Heard Mr. So-and-so learned counsel for the petitioner. Also heard so-and-so.
Don't read that.
Yes.
That we'll take it.
I'll just, yes, both the writ petitions as well as respondent number 3 served as senior lecturer in the District Institute of Education and Training, Gwalpara at Dudhnoi. Under Regulation 4D of the Assam Public Service Commission Regulation 1951, Commissioner and Secretary of Government of Assam in the Elementary Education Department by this order dated 4/5/2018 regularized the service of petitioner and respondent number 3 as senior lecturer of Diet on promotion with effect from the date of their taking over said charge. Both the petitioner and respondent number 3 took over charge as senior lecturer of Diet, Gwalpara, Dudhnoi on 1/1/2015 and in the gradation list of lecturer of Diet under the Directorate of SCRT Assam published on 26/6/2014, the seniority position of the petitioner was at serial number 33, whereas that of the respondent number 3 was at serial number 50. The petitioner joined as lecturer of Diet at Gwalpara on so-and-so, whereas the respondent number 3 joined as lecturer of Diet Dibrugarh on 8/8/1994, 2 months later than the petitioner. The erstwhile in charge principal of Diet, Gwalpara, Dudhnoi, retired from service so-and-so on attaining age of superannuation. The respondents in the elementary education.
You see the long and short of it. We come to page 148.
I'll just reading because to make your lordships aware of the facts involved in this case.
No.
But
whatever the fact, but the issue is that 2010 rules has to be followed in an early date. That is the operative direction.
Yes.
Page 148, third last paragraph.
Yes. In that particular case, taking into consideration the dispute involved, this was an observation made by this Honorable Court. This was a direction that you do it to resolve the dispute by following Rule 10. There was no challenge that rule, there was no issue that rules of 2010 will be followed or NCT. This was a general order passed by the Honorable Court with regard to the list involved at that writ petition.
I'll just read the operative portion, my lord. In view of the above, the order under so and so passed by respondent 1 and 2, the state government in the elementary education department director SCRT respectively allowing the respondent number 2 to hold the charge of the principal in charge of Diet Gwalpara Dudhnoi being illegal and bad in law and is hereby set aside. So the Honorable Court set aside and quashed the in charge business. Then directed respondent number 1, Commissioner Secretary Government of Assam Elementary Education Department shall fill up the vacant post of principal in the Diets of Assam, including Diet Gwalpara Dudhnoi, by following the provisions of said 2010 rules at an early date. So what was the purport or what was the decision? That in charge business is gone. You follow 2010 rule and go for regular filling up of post of principal. Now, if your lordships considers this operative portion with the DPC minutes that I have read, lordship will see the difference in the application. In the DPC minutes, they say, however, in WPC so and so, the Honorable High Court has in its, this is not with regard to, my lord, list in that writ petition, my lord. However, in WPC so and so, the Honorable High Court has in its order dated so and so directed the Commissioner and Secretary to Government of Assam shall fill up the vacant post of principal in Diets of Assam, including Diet Gwalpara Dudhnoi.
Just a moment.
I'm sorry.
You see, you're saying that this DPC has no relation to this judgment in.
No,
judgment
what
in
I'm
order.
saying is that, my lord, what I'm saying is that there was no law laid down in this matter by this Honorable Court that for the post of principal, you cannot follow NCT regulation. You have to follow rule.
No,
My lord, rules of
that's-
2010 was placed.
That's why I'm asking you this.
Yes,
This DPC,
Yes.
which is there at page 141,
yes, my lord.
is a DPC convened
Yes.
immediately after WPC 2293, or somebody else was promotion in between.
No, WPC 2293 was decided on 9/4/2019. And this DPC was held on 4/2/2021.
During this period.
This
was
is an
somebody
independent DPC, my lord. Because subject matter, your lordship will see in the paragraph that I have read, the above paragraph, lordship will kindly see, committee observed that there are 23 sanctioned posts of principal of Diet under Directorate of SCRT Assam. 18 of these posts are lying vacant for a while due to the retirement of erstwhile incumbents. For smooth functioning, smooth running of the academic as well as administrative works of this institute, these posts were to be filled up urgently on probation from post of, it should have been promotion from the post of senior lecturer Diet as per Diet Service Rule 2010. Against 18 vacant posts, 72 numbers of senior lecturer were considered under the zone of consideration 1:4 basis in the manner as per gradation list. So this was not in terms that comply with the Honorable Court's order. They were holding DPC, my lord. This was an independent exercise done for promotion of senior lecturers to the post of principal, wherein out of blue they have brought this aspect of the judgment to, my lord, create a, my lord, what I say, my lord, to create a thing that no, there is an order of the High Court that we have to follow service order of 2010. So as a one-time measure, we have relaxed the NCT regulations and we'll follow the rules of 2010. Till then, it was all right, my lord. Fine, you wanted to promote someone without any qualification. I don't have any say in this matter. But again, my lord, there is one, again they have convened another DPC, which is under challenge in this writ petition, that your lordship will find that has been annexed with the affidavit in opposition 7/7/2023.
Which page?
Affidavit filed on 17/8/2023. Lordship will find page 169.
Yes,
Page 169, Lordship got me, Lord.
yes, yes.
Yes. Minutes of the meeting of the selection board held on 7 July 2023 at so and so PM in the office chamber of so and so. For promotion to the cadre of principal diets and senior lecturer of diet under directorate of SCRT. Now, the meeting of the selection board was held on 7/7/2023 at 4:30 PM under the chairmanship of so and so government of Assam. For promotion to the cadres of principals of diet, senior lecturer of diet in Assam. The member secretary apprised the selection board about the number of existing vacancies and also vacancy to be occurred during the remaining period of the year up to the month of November 2023 in each cadre, and also placed the ACR statement cum seniority list, including information on submission of annual property return by the candidates brought under the zone of consideration of each cadre, principal diet. The member secretary apprised that at present there are 17 vacancies, UR 14, SC2, STP 1. The list containing the biodata and ACR of 60 incumbents in the cadre of senior lecturer who fulfill required criteria was placed before the selection board. Having gone through the ACR and other records pertaining to seniority and merit of the candidates, the selection board recommended the following candidates to fill up 17 vacant posts of principal diet. So all these persons, my lord, who are recommended from serial number 1 to 7, except serial number 5,
Yes.
all are underqualified, my lord. And serial number 7, Dr. Nirupama Barik Soikia, she was given promotion, white order dated 18/7/2023, immediately after the DPC, because they know that they can only promote PhD holder. So they have promoted others, they did not do anything. They promoted Dr. Nirupama Barik Soikia, knowing that she is a PhD. That order, your lordship will find page 151, annexure P25. She was given promotion to the post of principal diet. There was no decision with respect to the others. No promotion order issued.
Just a moment.
I'm sorry.
Just a moment. Mr. Ganguly, you got the information?
Yes, but I've taken instruction. These documents were not placed, my lord, when he filed the representation. These medical documents relating to appendicitis operation, this was not placed along with the representation. And your lordship will also find from the proceedings that this issue was never pressed by him. Be that as it may, my lord, we'll leave it to your lordship to pass.
No, then what we'll say is that we close this matter, ask them to file a representation, which should be reconsidered.
Lordship will say that and close it. We'll consider with, in reference to these documents also we'll consider.
Heard Dr. R. Sharma, and counsel for the petitioner. Also heard Mr. A. Ganguly, Leonard, counsel for respondent numbers 1 and 2. By projecting that the father of the petitioner, his wife and his specially able sister require medical assistance. The petitioner is seeking to be retained in the in which region?
Kokrajhar
In,
region.
in the Kokrajhar district. And accordingly, the transfer order of the petitioner dated 9/5/2024, as well as the earlier transfer order dated 18/4/2022 are from the challenge filing this petition under Article 226 of the Constitution of India. Next slide. The learned counsel for the respondents has produced a copy of proceedings pertaining to personal hearing provided to the petitioner pursuant to order dated 26/3/2024 passed by this court in WBC 2970 of 2022. And it is submitted that as per his oral instructions received and from the contents of the said proceedings, it appears that the medical documents which are annexed in this writ petition were not placed before the competent authorities.
Medical document at page 40. This is
At page
dated-
40.
Yes, this is
At
dated
page 40.
29th of April, my lords, and the
page
representation
40
is
of page-
26/3.
That is posterior to that.
Yes, that is why it was not there.
Full stop. Having noted the nature of grievance which is expressed by the petitioner, without entering into the merit and without determining the right of the petitioner, the court is of the considered opinion that without taking that the petitioner be permitted to submit a first representation before whom?
So, as the
That's one number 2.
HOD personnel. Lordship may say competent authority.
No, because he will not know where to give.
He knows, my lord, he has submitted earlier.
No, just tell me, HOD.
I think, yes.
Earlier it was the regional manager, your lordship. Was submitted. to
Because
the
it is
regional
the dealing person as far as transfer, my lord, it would be HOD personnel.
Huh?
The dealing person, the dealing authority would be the HOD personnel.
HOD
Regional-
personnel.
Yes, the regional manager would only be for the Kokrajhar. my lord.
Okay. Then before the head of the department, head of department within bracket personnel, Assam Gramin Vikas, Assam Gramin Vikas Bank, within a period of a week from today, along with all documents upon which he intends to rely on. Full stop. The said authority shall dispose of the representation of the petitioner within a period of
1 week thereafter.
within a period of 1 week thereafter. And the result of the determination shall be served on the petitioner, either by email or by WhatsApp. Next para. This order has been passed taking into consideration the nature of grievance expressed by the petitioner, and therefore this order is not to be treated as a precedent. Full stop. By granting liberty to the petitioner to submit a request representation, this writ petition stands closed.
Lordship, the disposal of the representation, I may not be disturbed.
First of all, the enforcement of the order of transfer shall be subject to the outcome of the representation.
Till the disposal of his representation.
No, outcome of the representation.
Okay, Lordship.
So the copy of proceedings, personal hearing granted to the petitioner, which is produced by the counsel for the respondents, is kept as a part of the record.
Lordship, 15 days time may be granted instead of 1 week here also.
No.
10 days at least. 10 days.
No. 1 week is 1 week. You are serving there. You are serving there.
Alright.
Obliged.
I'll take a short break and come back. Just give me
Lots.
some minutes. I'm compelled to straighten my leg.
Sure, fine, man. Lord, from the DPC minutes, it transpired that without the qualification of PhD and MAd with 55% marks, they have included senior lecturers who don't have that qualification, my lord, as mandated by the NCTE. Now, what is the stand of the respondents in their affidavit opposition? Lordship will kindly come the page 155 of the affidavit in opposition. Para 7.
You're referring to which the DPC page?
Page, I'm sorry, my lord, page 169 of that particular affidavit. DPC meeting dated 7/7/2023. This is under challenge in the present writ petition. Here only serial number 5 is the PhD. Rest all are underqualified.
Yes.
Now, the stand of the respondents in their affidavit in opposition, my lord, state respondents, para 7.
Yes.
That the NCTE prescribed the norms and standards for different teacher education programs only, not only for the teachers' education institutes. The prescribed qualification stated in the petition is applicable against B.Ed course only. The promotion of the principal and senior lecturer are governed by Assam District Institute of Education and Training Service Rule 2010, hereinafter referred to as Service Rules of 2010. Rule 5 of Service Rule of 2010 provides that post of principal shall be filled up by promotion from the select list of vice principal senior most lecturer. Similarly, Rule 11 provides the manner of recruitment. This is not relevant. The most relevant portion is that what they are trying to say that NCT provides for the teachers program, not for the teacher institutes. It's true, my lord. NCT only provides for the program, BA course or any other course. It doesn't say that diet has to perform diet principal or any particular institute has to principal or lecturer has to have this qualification. Overall general NCT will prescribe. Now they say the prescribed qualification stated in the petition is applicable only for the BA. They say that the prescribed qualification by the NCT is only for the BA. For delete courses, it's not applicable. And they are putting an argument that it was part of the previous order also, my lord, a submission, that there is no B.Ed course in diet, my lord. That is absolutely wrong. My lord, as on date, I'll just place the data, my lord. As on date, there are 27 diets. Lordship may be pleased to note down, of which,
Just a moment.
I'm sorry.
Yes.
As on date, there are 27 diets in the state of Assam, of which 14 imparts B.Ed as well as delete both the courses.
B.Ed and
Delete. DLED, my lord.
LED.
Yes.
Yes.
So out of 27, 14 imparts both the courses. I don't know how the government is going to deal with this issue, my lord, because they are digging their own grave by not following the NCT regulations. They say it is only for B.Ed, not for diet. What will happen to the institution wherein B.Ed is also imparted? They are totally silent on that aspect of the matter. Now, para 8, there is another, there further stand. In view of the above extant rules of service rule 2010, there is no ambiguity as to that the post of principal diet is a promotional post, which are to be filled from the post of vice principal senior lecturer having the experience as prescribed. Service rule 2010 nowhere mandated that the vice principal senior lecturer of diet must possess PhD degree for promotion to the post of principal. Further, it is necessary to mention that the PhD was never a prescribed qualification for the post of lecturer, senior lecturer, vice principal, not to mention even principal of diet. Because the NCT regulation came in 2014. The service rule is of 2010. So definitely the prescription given by the NCT in 2014 will not form part of the service order. Just like you have done in the case of lecturers, that you have issued a notification in the year 2021 incorporating PhD and M.Ed with 55% marks in the qualification for the post of lecturer. You should have done this. So no such thing was done, and once they have violated in 2021 DPC, then again they have in the impugned DPC, they again followed service order, overlooked the NCT regulations 2014 and are making attempt to promote person who doesn't have the qualification of 55% mark with M.Ed and PhD degree. Now in para 29 of the writ petition, page 23, I have given the names of the persons in the cadre of senior lecturer who are having the qualification of PhD degree, my lord.
That we
Para 29.
that
There are only seven senior lecturers.
no, that may not be considered because this is not a representative capacity
No, no,
This
I'm not,
are-
I'm not, my lord, espousing their grievance, my lord. I'm
That's
just
okay, we are
placing the,
considering your case, whether there are others or not, we are not
Yes.
really interested right now.
yes. My lord, my, including the petitioner, there are 7, my lord. Now, this is the stand of the respondents in their, my lord, there is another contention. Page 157. Para 9, my lord. That the answering deponent begs to submit that, however, after coming to the force of NCT Regulation 2014, as amended in 2017, the government of Assam has issued notification dated 15/12/2020, my lord, annexure P21, my lord, I shown that by revising the existing minimum qualification for all categories of post of diet, government BT colleges, colleges of teachers education and SCERT as per norms and standards prescribed by the NCT. So for the principal, you say the NCT regulations are not applicable. Service order of 2000, service rule of 2010 is applicable. Now here a contrary stand that for all other categories of posts, we have issued notification as per NCT. The minimum qualification for the post to be filled up by way of direct recruitment through APSC only was revised, not for the promotional posts like principal, vice principal, senior lecturer, diet. That means you know it. That for promotional post also minimum qualification has been prescribed by NCT. Now with regard to, I'm sorry. Now with regard to that DPC held on 4/2/2021, their stand is ambiguous, my lord. They say DPC meeting held on 12/2/2021 instead of 4/2/2021 for promotion to the post of principal diet. No such resolution was taken by the said DPC in regard to PhD degree. Based on such recommendation of DPC held on 12/2/2021, promotion were given wide notification dated 25/2/2021. So basically, my lord, they are denying that there was any DPC held on 4/2/2021. That is, my lord, page which I referred to, my lord. Page 141. They are saying no DPC was held, another DPC was held on 12/2/2021, and in pursuance to that DPC, promotions were made. So they deny this. 4/2/2021, there was no DPC.
Yes.
So my submission before your lordships is that, my lord, rules, the state rules 2010, the NCT regulation came in 2014. You are bound to follow the NCT regulations, my lord. You cannot violate the prescriptions contained in the NCT regulations. If the NCT regulations has brought in qualification for the post of principal, you are to follow. Whether you do it by virtue of a notification, whether you do it by virtue of amendment, it is your duty to do that. In the case of lecturer, they have issued a notification in the year 2020 that we are changing the initial qualification. But so far as principal is concerned, they are not doing it. They are sitting tight over the matter. And out of the 14 diets wherein B.Ed is imparted, the respondents are without any answer. What will happen to those B.Ed, those diets wherein B.Ed is imparted? What will happen to the qualification for the post of principal? They very conveniently said that NCT regulations are only for B.Ed. Fine, then promote.
I don't know. You please see this page 4 of your writ petition.
Page 4, my lord. I'm sorry, my lord.
From there onwards, you'll find that NCT is not even a party here. So
SCERT
My lord,
So the best person to tell us.
State
whether-
Council of Educational Research, my lord, is a party here. It's a body under NCT. My lord. I referred one letter to your lordships, wherein the State Council SCERT has issued communication to all the principal diets that you follow the qualification prescribed by NCT for the
Who's-
post of
who's
lecture.
appearing for respondent number 3?
Mr. P Nayak, I think, appeared. For B Chaudhary or P Nayak.
B Chaudhary was,
B. Chaudhary.
they have signed their affidavit also.
Okay. Okay. Yes.
So what they are saying, my lord, what will happen to those diets wherein B.Ed and D.Litt both are imparted? That means going by your stand, it is applicable only for the post of, for the course B.Ed course. Then in those 14 diets, you have to follow the NCT regulations, my lord, of 2014, which you are not following in considering the senior lecturers in the DPC dated 7/7/2023. Now, the affidavit filed by the SCERT, your lordship will find page 201, it starts.
This will things relevant stand is at page paragraph 11.
So, sorry, my lord.
Paragraph 11 is the relevant stand.
Yes.
Yes, paragraph 11, my lord. Same thing like the state government. Service order of 2010, there is no mention of the requirement of PhD. So
No,
we'll
they
go
say-
by that.
They say that PhD is
Not mentioned.
no. They say that the requirement is only for B.Ed
Fine.
program.
Fine, my lord. Same state has also said that NCT regulations are only for B.Ed. So since one contention was urged before this honorable court said because there is no B.Ed in diet, so all are D.Litt. So it can be done without following the NCT regulations, my lord. It was a submission made, my lord. It was recorded in the previous order of this honorable court. Now the stand is absolutely identical that NCT only provides for B.Ed course. Now the question is, how you are going to mend the 14 diets wherein B.Ed and D.Litt both are imparted? That is absolutely silent, my lord. You cannot violate the NCT regulations going by your own stand. My plain and simple case before your lordships is that, my lord, there is a body, NCT, it's a statutory body under the act. It is a pan-India, it does a pan-India, my lord, observation, and it gives recommendation. So the regulations of NCTE are binding upon the state government. And in fact, they have accepted in 2020 letter, in 2020 notification with regard to the post of lecturer, the very first paragraph they have accepted this contention.
Where is the foundational facts in your writ petition saying that they are carrying out B.Ed course also?
My lord, I have annexed one, my lord, in my reply, my lord. No, this question came after their affidavit in opposition.
Okay.
My specific stand in the writ petition is that NCT regulations are mandatory and the diets principle are to be promoted following NCT regulations. Now, one example I have given in my affidavit in reply,
there are 14 these like this example. One example I have given to show that diets impart B8 and delete both the courses.
Where is that?
Page 192
192.
of my affidavit in reply filed on 11/9/2023, my lord.
192.
192, my lord. My lord, I would like to read 2-3 paragraphs of this order, my lord. Whereas in terms of section 15(1) of NCT Act 1993, District Institute of Education Training, Street Road, Morigaon, Nagaon, so and so has applied for grant of recognition, permission from given below program for online so and so hard copy, B8 and delete. Additional intake, 2 years. Now, page 193, serial number 5, your lordship will kindly have a look.
Mr. Das.
I'm sorry, my lord.
No, don't be sorry because I have not even spoken what I'm going
No,
to
no,
say.
I
You
thought
see-
that your lordships wanted to
No,
convey.
no. You see, what happens is that you should always remember that I come from a very awkward background.
No, my lord.
On the, it is on the left side of where I am sitting. You see, unless there is a foundational facts period, the issue that it has to be responded to. Because nobody makes a response by looking at the annexures and then saying, then contributing.
I had stated in my
That's
body
what
of
we
the-
are asking, where is that?
Yes, my lord. I'll just refer, my lord. I'm sorry.
Because if you say somewhere that they are imparting B.Ed course and then they have not responded, then it would be an adverse influence against them.
Yes, yes, ma'am. Para 8, my lord.
Page?
Page 175. It starts.
175. Ah, yes, that's okay. This is the only thing I want.
Yes. Lord, sorry, my lord. I just failed to, my lord. My lord, your lordship also can refer to a submission made on contained in the order dated, recorded in the order dated 13/10/2023. The submission of,
Just one.
I'm sorry.
Yes, order dated.
Order dated 13/10/2023, wherein at para 3, a submission made by respondents was recorded, wherein it was submitted that diet only imparts delete. So that
No,
is
no,
the
that's not the submission.
no, last line.
Mr. Chaudhary's submission recorded was
I'm sorry.
that where is the institution where the respondents are appointed?
Yes.
So he's qualified. He's not saying all diet. He's referring to only those
Very-
diets where the respondents are working.
All the respondents, my lord, cover all the vacant posts.
I don't
Very-
know. I don't
That
know.
is my lordship. I just leave it. Lordship may skip that portion, my lord. I'm not referring to that order. So, my lord, DIET impart both the courses. So it's not a fact that DIET only imparts DLIT. So how you deal with NCT regulation in maintaining the standard of education in the state? Because NCT provides regulations so that the standard of the education in the state is maintained. And you are violating those regulations to facilitate promotion of some senior lecturers who are not qualified to hold the post as per NCT regulations. That is precisely my case. So you cannot go beyond the regulations of NCT. You are bound to follow as a state. You have already followed in case of lecturer. Why you are shying away? That is my submission, Milord. And in that event, the persons who have acquired their PhD, they will, Milord, their service will be degenerated. Milord. They'll definitely have the expectation that we have got the PhD and NCT regulation provides for PhD holder for the post of principal. Milord, one judgment I am relying on. On this issue that how state should react under such situation. What is the duty of the state? Citizen 2013 to SCC 617. ಎಲ್ಲಾನು ಮುಟ್ಟಿವಾನ ಜಜ್ಮೆಂಟ್ करना है आज ना लगे तो Lord, I am relying on para 59, Lord. Lord, I just pause.
Just give me the NCT national.
Lord, I have a copy, Milord.
National.
The ex
What is the full name? National Council for Teacher Education.
Teachers Education.
National.
हम दे रहे हैं। हम direct ना पाप होता है कितना होता है
Possibly, there is no direct, madam.
There's no direct.
yes
2014.
no 1993 93 ये कैसा था बोलो फाइल में दे देंगे ये इसमें दिन भर में direct night UGC UGC Okay.
No, I just keep to show one document to your lordship.
You are referring to this.
I'll come to that,
Okay,
my lord. I'll
okay.
come to the judgment.
Okay.
Prior to that, my lord will kindly come to page 192 of my affidavit in reply. That is the order by which I showed that both the courses imparted in diet, my lord. Second page of that particular order, my lord. I'm just trying to show the consequences, what will happen. And what risk the respondents, that means the official respondents are running, my lord. Page 190, I'm sorry.
No, please continue.
Page 192, down below serial number 4.
Yes.
The institution shall comply with various other norms and standards prescribed in the NCT regulations as amended from time to time. The institution shall make admission only after it obtains affiliation from the examining body in terms of clause 810 of the NCT regulations norms. The institution shall ensure that the required number of academic staff duly approved by affiliating body for conducting the course should always remain in position. Further, the recognition permission is subject to fulfillment of all such other requirements as may be prescribed by other regulated bodies like so and so, so and so, so and so. The institution shall submit to the regional committee a self-reprisal report at the end of each academic year along with the statements of annual accounts duly audited by a chartered accountant. Serial number 6, the institution shall maintain its website with hyperlink to the council and the Eastern Regional Committee covering inter alia the details of the institution, its location, name of the program applied for, with intake, availability of physical infrastructure such as land, building, office, classroom, other facilities or amenities, instructional facilities such as laboratory, library, and the particulars of their proposed teaching faculty and non-teaching staff with photographs for information of all concerned. The information with regard to the following shall also be made available in the website, namely serial number B, name of faculty and staff in full as mentioned in school certificate along with their qualification, scale of pay, photographs. Now, my lord will kindly come to the next page, my lord, page 194. So apart from prescribing the qualifications, there are other prescriptions by the NCT. What will happen if the state fails to adhere to those conditions, my lord? Page 194, serial number 10, it provides, if the institution contravenes any of the above conditions or the provisions of the NCT Act, rule, regulations, and orders made and issued thereunder, the institution will render itself liable to adverse action, including withdrawal of recognition, permission by the regional committee under the provisions of section 17.1 of the NCT Act. That means if you don't adhere to the regulations, the institution may lose its recognition. So if a B.Ed, if a diet is imparting B.Ed and you are not following the qualification prescribed by the NCT for the post of principal, then your recognition may get withheld, or you may lose your recognition, because without recognition of NCT, you cannot run a diet, my lord.
Mr. Chaudhary, we can take it up day after tomorrow.
My lord, if it is not inconvenient, day after tomorrow, my lord, I'm tied up in so many cases. Could it be any other day? Maybe next Tuesday or Thursday, my lord.
Then we go to 4th of June.
Election day. Election result day.
4th of June. Oh, you'll be busy. You are in now into
Little
politics
bit,
also.
little Because my party is also little bit.
No, that's okay.
It is
six-
it is sixth, my lord. I think my learned friend can conclude today, then we will.
No,
then
because I have a meeting at
Okay,
4:30. I have
okay,
to
okay,
raise.
my lord.
The submissions of Mr. H.K. Das, learned counsel for the petitioner remains inconclusive. Mr. K. Chaudhary, senior counsel, assisted by Mr.
My lord, yes, sir.
S.
Hazarika.
Hazarika, counsel for the private respondents. And Mr. B. Kaushik, learned counsel for the elementary education department. And Mr. V. Chaudhary, learned standing counsel for the SCERT are present. Next matter is agreed to by all sides, list on 6/2024.
Deep dive.
Next time you'll have to make one more, you have to also convince the court. Once there is a earlier order of the court. How this bench can take a contrary view.
All right, I'll satisfy.
Hopefully everything goes good for you. Because you can always give good wishes. Yesterday I came to know that